Hey all, here is a replay version of the most recent live stream Q&A on all things Social Security that occurs every Wednesday at 1 p.m. Eastern Standard Time. So this is with all of little silences carved out of it. So I hope it's an easier listen for those who are doing the replay versus being there live. And we'd love to see you live. So feel free to pop in. Bye-bye now. Hey guys. Hello. It's Wednesday, August 20th, 1 p.m. We are right on time here. Give me a quick, gosh, a few of you are here. Very nice. And a lot of posts already. That's great. Getting in. I see you got in nice and early. We can hear you. Thank you, Beth. Thanks. I appreciate. Okay, where are we at? First, I just want to give you the quick rundown for some of the 12 a.m. dailies that are coming out tomorrow. Friday is obviously the fraud law review. This one was a Georgia SSA staffer who ripped off 28 victims with changing their direct deposit. And I think this is why they want us to do it through our own little portal access to the SSA. So that can't happen. He was busted though, of course. Anyway, that's coming up Friday, Saturday, or at least upcoming. I'm not sure what day. Just a list out of the new compassionate allowances that they released the other day. So 13 new 2025 compassionate allowances. I think it brings us up to 300 compassionate allowances. So it's been growing, which it needs to. And they're all like things most of us have never heard of. We have one coming up on protective filing, what it does and what it does not do. That came from a recent Q&A when someone was under the impression that perhaps a protective filing would kind of be putting them on an expedited basis where they could jump ahead of other people in terms of speed and getting to decision making. And we kind of clarified that a little bit. There is one coming out a little bit about, and again, it stemmed from a Q&A on Social Security disability, SSI, Medicaid, and Medicare, and the confusing little overlays that take place between all of those. We have one coming about stress. Is it a disability? Is it a symptom? What is it in terms of the legalities? And then upcoming also at some point, I don't know when these are going to be exactly queued. The question of, can attorneys get fees from your future benefits? Like if that 25% could be tacked on to future benefits. So we go into that. Okay, that's just in case you're interested in any of those. I want to catch them. All right, where are we at? So thank you guys for getting here. I appreciate it. Looks like the first person that was here nice and early, way early, but I guess it lets you post comments. So that's kind of cool. If I butcher it, I apologize. Huna, Maraca, or Maraca. I would be saying Maraca, but I see that little squiggle over the first A, so I don't know. Let's put you up here, Huna. Huna asks, can I reopen my 2023 SSDI claim that was denied and closed after several reconsideration attempts that didn't go through? Okay, that's the initial part of the question. I have known of, we have done reopens. Now you have multiple, so it's a reopen. You'd be seeking a reopen of the most recent. And then when that's reopened, ask them, you're going to ask them probably all at once, but then again, reiterated. If you get one reopened, you try to ask that adjudicator or the judge you eventually go to reopen the one before them. There are situations when they can do that. I think they are time limited unless it's a particular kind of exception. Incidentally, guys, I don't have green screen, and you could probably see a little bit of fuzz and bop about my head, but I just didn't have the time to get it up in these quarters here. So we're kind of working on a fast roll. So you can ask for the reopened, and you do that on your next application. She goes on to say, or he, I'm sorry, I don't know, man or woman, I started working again, but had several failed job attempts in the last 2 years. Okay, I get it. A lot of times a reopen of a closed initial or reconsideration, whatever your most recent was, that was not an ALJ finding, might best be served if you can point to what they had that lacked something that existed at that time that the SSA adjudicator did not get, that might have changed that result. If you can find something that was missing from the medical evidence, by and large, medical evidence. And it's not that unusual that they didn't get Dr. Jones because they figured they had enough to deny. Not necessarily, right? Yeah, and I get it. Sometimes when people start working again, if they get it in now, they're like, well, you know what? I'm just going to hope for the best and that this work continues and all that, which often it does. And then they get past 6 months, so it's a successful work attempt. If you didn't get past 6 months and you reapply, you could try to assert an onset date before any of those shorter-lived work attempts occurred. I mean, there was a certain math to it, but since you might not know the math, if anything, going backwards in time, if you look at all the prior work attempts, was the most recent one less than 6 months? Okay. And the little gap in no work before that, was that at least a month? Okay. Then go to the next work right before that. Was that less than 6 months? Okay. Was there a 1 month gap between that and the prior one? And those could all, in theory, be failed work attempts. Of course, it's going to depend on whether your medical evidence supports you were disabled at that time and that was your attempt to go back to work. We can never be sure if we are unable to do any job out there. And oftentimes we get a job that is really special and there are not a lot of them out there, but it could be through a family friends company and they know your problems and they accommodate them nicely. So, that could be part of the reason why it lasts as long as it does. But if it's less than 6 months, it would be a failed work attempt. Also, if it was under SGA, even though, you're working, that wouldn't even need to be argued to be a failed work attempt because it was under SGA and it doesn't count. All right. Because remember, we can all work even when we're collecting or pending under SGA, so long as we are otherwise disabled medically, as per the evidence and all that. Huna goes on to say, I was injured at work in February 2025 and now require 3-level ACDF spinal surgery, cervical radiculopathy, arthritis, and PTSD, all in the original claim. I currently receive IHSS for some ADLs. Okay, I just got a case with IHSS income, and I haven't yet determined if it's considered wages or more of a stipend. So I'm waiting for my new client to get me the tax returns and see if there's W-2s or any other indication of what that is. And also to see, because there was other work too, I can kind of figure it out maybe from the tax return, if the total wages was X and it all matches the actual work and not the IHSS, I'm going to probably be able to figure out that the IHSS was not taxable. But keep in mind, the IHSS, if it is taxable, can get you credits. Like if it's taxable for Social Security purposes as wages, you could be keeping your credits going so that when you do file and win, you will be insured for the SSD at that time instead of it expiring with a DLI that would be breathing up on your back. Those part-time works you did, Huna, also probably contributed to getting you credits during those years you did them, assuming they weren't just $50 here and there. And that too could help you make a different result in your claim in the future when your whole situation changes. Your medical condition can be getting worse. You said you're now at the point where you need to have a 3-level ACDF surgery and you might have an age bracket change. All those can vastly change the likelihood of prevailing on your evidence. He or she says, last semester I lost financial aid due to having to drop classes due to decline in executive functioning. I am almost 49. So you are at the very difficult spot of being under 50. You don't get any of those slightly better rules that occur once we hit 50 in terms of our ability to adjust to other work, aka the GRIDS, medical vocational rules. He has many gaps in employment throughout my life due to disability. So, when you end up getting, the gaps aren't so much probably going to help you with an adjudicator, but if you go to hearing, I do think the ALJs, because they have such a broader view and they're not really filled with only check boxes. They can use discretion and they can use their intelligence and their mind and see, the history of someone's very gappy work due to medical problems can help evidence the difficulty of staying on a job, and that it wasn't just because you were there 8 months doesn't mean that it was easy. You can't win back during those 8 months, but that can be evidence for now to show, yeah, she's got this growing history of, troubled, work getting more difficult, more difficult, more difficult. And that was when she wasn't as physically impaired as she is now. That was maybe just through mental. So it really does depend. And so going back to the question, she says, can I appeal 2023 or do I well, first of all, you can't appeal it now because it's out of time. You had 60 days, you didn't do it. That's pretty much done unless you were in a coma in the hospital or maybe just in the hospital all that time. So that probably, you can't appeal it. However, you would reapply and you would specifically ask for a reopen of, and know your dates. Know when you applied the most recent time. If that's the one, you need to get that reopened before you can jump back to the one before that and ask for that one. So you'd have to succeed in the one right before, and then you'd have to ask for a reopen. Once you get that one, a reopen of the other one. You could lay it out in your remarks and your application saying, this is what I'm hoping to do. I would like you to consider reopening my so-and-so application that was denied on reconsideration on so-and-so date. And by the way, the timeframes of deadlines for reopenings stem from the initial, and I think it's the initial denial. Don't hold me to it. So their initial filing or initial denial, I think it's the initial denial. For some reason, it's not the recon that came after. So like if there's a 4-year limit or a 2-year limit, knowing all those rules is helpful, but don't wait to learn that. Don't wait to apply and request a reopen just because you don't know those rules. That's something you can look up later. So you would reapply, request a reopen of the prior application. And if you can state the basis, you can't just say, because I want you to, because I'll get more monies. You want to know, you want to indicate why. They were missing my orthopedic records. I could see it from the, and you'll know if they were, because when you look at your initial denial that came with an explanation page, they have a list of what providers they received something from. They don't tell you what it was, but they received something. And if that orthopedic group or whoever it is not there on initial and also on recon, that means they never got it. So that can be your hint. The better way, of course, is getting your entire file from the SSA. We do have videos on that. But that takes time sometimes. They can be very slow. It's not their priority. If you do make a request on the 3288, I would, within a week, maybe call and follow up. I would stay on them. Now that we've got more people in the offices and more people handling phone calls from the field office, thank goodness. It's not great yet, but it's vast improvement. You might have a better chance of getting them faster. But you can look at those things that you did receive in the mail, assuming you filed them properly, kept them in a box, something didn't throw them out, and you can see that list, that kind of vague list of received this hospital, received this orthopedist, or didn't receive this orthopedist. And then you can know, you look at what's missing and compare it to your realities, and then you know what they didn't have, and that might be a basis for getting the reopen. All right, we have Luis. He was number 2 here, bright and early. Thank you, Luis. It's nice to meet you. I don't think we've met. Again, sometimes I do forget a name, but usually I kind of remember them. Like I know I haven't met Huna before. Facing an appeal, Luis, is it Luis or Lewis? I have clients with that name, and sometimes they pronounce it 2 different ways. Different people pronounce it differently. I'll say Luis. Facing an appeal that was filed, with your help. Well, that's very nice. It addresses a decision by SSI, I think you mean SSA, the Social Security Administration, not Supplemental Security Income, right? SSI doesn't make any decisions. It's just a program to recoup benefits from my brother-in-law for a period of 9 months in where he was audited and shows to have, this sounds complicated, in his account money exceeding $2,000. My brother-in-law has received benefits from SSI going on almost 30 years now, and it was put on SSI after receiving mental health disability diagnosis. Wow, Luis. This almost rings a bell. So I guess, did we meet or no? Maybe it was someone else with a similar problem. I just don't recall the last name. Anyway, Luis goes on to say that from his doctor and with the help of his father, who served as a conservator for the duration of benefits, received up to the period and where the system showed the excess of $2,000 in his account. This reflects only because his father passed away and the money was not his, but was turned over to him because the accounts and the responsibilities were of his living situation were reverted back to him. Upon speaking to the initial auditor and several specialists thereafter, they failed to realize, 1, they were dealing with a person who was mentally challenged. That doesn't matter. 2, upon answering question upon the excess funds, it would matter if they're trying to get information from him today. It wouldn't matter if he had someone that was overseeing his monies and they screwed up. You can't just say, well, I was mentally not with it and I did have somebody doing it for me and they screwed up. That won't make for a non-overpayment. But anyway, let's continue. Mentally challenged. 2, upon answering question upon the excess funds, he was answering honestly when saying that money was not his. It was his late father's and didn't know, had proof that it wasn't his, had worked to return it. That will help with showing what you probably don't need to show, which is no fault. So there wouldn't be a blame game and more dangers. Let's continue. Had worked to return it, for it was home loans and other debt he could not cover. You mean it was proceeds of loans, not the actual, it was loaned money, I guess you're saying. He could not cover, but needed time. To make a long story short, they did not believe him under the current climate of all the SSI fraud that has been in the news. I want to know why you think that the reason why they didn't believe him. Why do you think they didn't believe him? Because even if they believe him doesn't mean that they can change the law, right? And 2, why do you think it's under the climate of SSI fraud? It would always be the case. But let's see what more there is, Luis. They have found him guilty. Guilty. Are you saying he was prosecuted? Because that's the only way that word guilty comes into play here. Despite our efforts over 10 scheduled calls, it sounds like what you're saying is they found him in overpayment status, notwithstanding what you think are mitigating circumstances. So I wouldn't say guilty. That's really a misterm there. Guilty says that they said he was guilty of a crime. We are only guilty of crimes, not even of mistaken monies in our way. We could be liable to pay them back, but that's a civil thing. It's not a criminal thing. And it's an important distinction because If someone is at fault in an intentional way, they will prosecute you. If they don't do that, you know that they don't think that. None were kept by the specialist. Over 10 scheduled calls, none were kept by the specialist. I don't even know who that is. 7 house visits, none were ever met by the specialist. Who is the specialist? I think maybe, I don't know. That's not a word they use. And yet this was done after we complied with every single request to avoid any possible negative outcome and to prove it wasn't his money. No evidence was, well, I'm glad you're appealing. No evidence was ever reviewed. No, they never do. All these overpayment situations, they just tell you what their conclusions are, and you have they're very scant facts. And sometimes it's you're definitely right on that point. No information was ever discussed. Your appeal was effective. Yeah, just got to appeal it, take it all the way up to a judge. It really doesn't, when you say it wasn't his money, was it his money? It just came from someone that it wasn't his money until his dad died. Somehow the money ended up in his account. You're going to have to really dissect. And I say, was it his money or wasn't it? Sometimes a person has been on, and I don't represent on these, by the way, but I just read some of the cases on it. A person could have a joint account with their mom, and their mom has money, and the mom put them on it so that they could help. The mom can't maybe get around, so this person could be there in case she dies. They're not touching the money, they're not paying her bills, but she wants to have someone there, so it'll be like if she passes, that money is quickly that person's and all that. Not the best estate planning under the circumstances, but they don't know that. And if there is times when a joint account, it takes proof that the person, it was not theirs. They didn't put that money in there. Somebody else did. The other joint bank account holder was responsible for any monies that went. To probably dissect every piece of money that went in there and show that your brother-in-law did not take any of it out, nor did I assume he had a representative payee. I would have expected that to be the conservator under these circumstances, because they are not necessarily the same thing. So the facts aren't entirely clear, but when you get to a judge and you literally, I would be dissecting every in and out of that bank account. I would be doing it in a chart. I've done this with 70 page brief attachments with charts on one of the 2 last overpayment cases I did, which convinced me never to do them again. I mean, they both turned out successfully, but I probably spent $200 because I'm anal and I got to win it. So when I know the person didn't do it, you know what I mean? But if the money went in because it was an inheritance and the law of inheritance or the inheritance attorney or whatever put it in there, I mean, it really depends on those facts, Luis. And I know you can't explain it all here. If it was something he inherited, it went in and he just didn't know and he didn't know to get it out of there, that is going to be a problem. It's going to be a problem. So the money is presumably still around though, then, and he can use it to pay back the SSA. He could also, once he's back down to nothing and it doesn't just like give it away to somebody else, he might be able to get a waiver of any overpayment. And that would be, because he's going to be assuming he didn't inherit a lot where he can self-sustain. If he's going to be on SSI again, they might be okay with that. They might be understanding of a waiver. And that's, again, assuming he's dire poor, or there's a special needs of trust or something that takes the monies out of it. But I don't know. I don't know I don't know the ins and outs of how they would handle an SNT when you have an overpayment that you got, when there was an SNT that could have paid back. Do you know what I mean? Like what came first, the cart or the horse? So yeah, asking for a waiver when you still have a bunch of money in the bank is not really going to work. You want to pay the money back, and that's assuming you can't prove that he doesn't owe it under some of the rules we're kind of tossing around here. And this is obviously not, exhaustive. But when you get, you have time before the hearing, it's probably not even scheduled yet, right? You can get this together. I mean, I'd make organized. It's going to make your brain hurt, your eyes hurt, make you bleed. And it sounds like you've already been doing that. But now you've got to put it on a really cohesive, organized, with attachments, with citations to the attachments of every little documentary piece of evidence you want to show. And that would include the bank account and where every little line by line came from. That's where I'm saying a spreadsheet, but you still want to include the bank account because that's where the spreadsheet numbers came from. I mean, you could, in theory, have the printout of the bank account statements and take a little note next to each line explaining where it came from and say, see exhibit ZZB12, because there's going to be 5 million exhibits or attachments, whatever you want to call it. And that would be proof that that money was put in by dad or something. My brain is already hurting for you because I know how arduous it is. Luis does go on to say, simply as it states, they did not review, present, or withheld evidence and yet still found him guilty. Again, guilty is the wrong word to use, and you're going to look really, they're probably just going to think you're ignorant of the proper language, but it could also look like you're being inflammatory. So remember, you want to keep it, you don't want to accuse people of being dishonest, and you don't want to accuse them of saying he's a criminal, because that's not what they've done. If this is all still in the SSA, they were only saying he has an overpayment. It has nothing to do with ill intent, criminal intent, anything like that. And that's what guilty has to do with. So just be careful how you toss it around, because you can get people are human. You can get them a little aggravated too if you're accusing them of being that way. We've gotten our local congressman involved. He has reached out to them. Yeah, he can't change the substance, and he can't put his thumb on the merits and do favors for you that everybody else in the same position wouldn't get, but he can make them speed up. But do you want it sped up, Luis? Because you've got a lot to do in terms of organizing that information in a brief for the judge, which is different than what you've done. If you just blizzard the judge with a bunch of paperwork and expect him to figure it out, that's not going to be a good idea. That's expecting a lot of people that are very strapped for time. He's got attorney advisors and helpers, but you want them to see what you see. So you need to lay out, here's what happened. Here's this date's money, and it was not put in by this guy, and he had no access to it. That's another big thing. Did he have access to it? If your brother-in-law did not have access to that account, even though it's in his name, because he did not have the mental acuity to even get into a bank account, that could be in your favor. So that is where the mental health component certainly can come in even more. Proof that he never was in there and he could not have been in there. So even though it was in his name, he really had no dominion and control in reality. And that's an important factor, is dominion and control. Legally, he had dominion and control, but in reality, he couldn't. Let's say someone's in a coma. They have a bank account. They really have no dominion and control of their own, really. You know what I mean? Woo, okay, keep going. He has reached out to them. I'm still with you, Luis. Secure a pro bono SSI attorney, but most community attorneys don't specialize in that discipline. This is very true. I want to do all I can to help overturn what I believe is unjust. He is disabled and is now caring for. He is disabled and is now caring for other brother. Wait a minute. So your disabled brother is able to care for the other brother? Be careful. The same specialist also stated to audit his brother too. I get the feeling that he is less interested in truth and more in just catching people. Well, you got it. You have to give them the facts. I know you tried to, but maybe what you're giving them isn't changing what the law says has to happen. So you have to address the law on that. All right. I know it's not easy. And I know you want pro bono, obviously. Who doesn't? The people that do this kind of stuff, and like I said, I did two that ended like a year ago. And it was about 4 years worth pro bono. Yeah. And you just can't, you have to close up shop like a viable business and just be a volunteer person, maybe a trustafarian who could do that kind of stuff, because most people can't. And it's true. And you're right. The legal aid people are not going to, they can't even do Social Security to speak of. They're not going to be able to do that. They're not going to just have the hours available, because they're going to have to stop helping everybody else, because it's going to be so many hours. I don't want to scare you. You probably already know based on what you've seen. But if you organize it, Luis, I mean, I know you can do it because you're obviously very smart, but do it more from a math and objective point of view and without your heart in it the way you are, because that's going to divert you from the things you need to show. So you have to be very objective, okay? Luis is saying that I get the feeling that he is less interested in truth and more in just catching people and approaches things as a one-size-fits-all type of attitude. I don't think so, and I'm not defending them, but it's your duty or your brother's duty, if he didn't get himself a representative payee, which he should have perhaps, particularly if he's able to take care of a disabled brother. And I could be mixing up those people, and I apologize if I am, but I'm just trying to show you what sounded alerting to me. If the rule is broken and there hasn't been proof that it hasn't been broken, they don't have a choice. They can't just play favorites and, this person's sweet. So, it can't work that way. And I know it's frustrating, but that's why you just have to put on your objective hat and say, I'm going to get, and you'll have a judge who will listen. And that is a big difference. The judge is going to go through that nitpicky, because if the judge fails to, it's going to go to federal district court if you take it there. And the judge has to, unlike the down belows, if he were to deny what you're claiming, he has to explain each and every basis of why. And so now you're going to have his argument or whatever. But I do find that the judges are really, I don't think I've ever had an overpayment not succeed. And again, I don't do them anymore, because I can't even, I had to cut off probably I feel like 20 clients, from taking them, because I always stay within my human limitations of doing stellar work. So, but if you just try to get it as laid out for the judge as you can. I find them to be very, very, and they have attorney advisors that are good with the math too. And they do go through it anally. It's different from below. I understand the why, assuming all you say that for sure that the law is not on their side, it's on his side, not just the feelings about it or the fairness. If the numbers are there and you have those receipts that prove who deposited, who never took any out, and what was never taken out by representative payee for your brother, that should, that would show it was more money being taken out, all that stuff, they will look, they will pay attention to it. I will say, I do feel like down below, they don't. It's too much time. As much time as it is for you, it's even more time for the person who's learning it, who's not familiar with the facts. I distinctly got the impression on both of the overpayments of the last few years that they did not. Because you could get someone on the phone who says, oh, I think this is going to be okay. This makes sense what you're saying. But they weren't the decision maker down there. And next thing you know, you're getting a rubber stamp of denial. And now you have to go to ALJ. They didn't read it, because everything laid out was entirely logical, fact-based, supported with documentary evidence from the SSA itself, if not, and other sources. And they clearly didn't look at it. And that's why the judge came back in our favor. And again, very, very nitpicky. There were charts month by month. I had a monthly chart going back to, I think we were talking 2024. Anyway, all right. I've got an eye doing a weird twitch here. Let's see. Luis goes on and says, anything you can do to help and my family prepare for the appeal hearing. Oh my God, your appeal hearing is that soon? Did you get your brief in with all those attachments? Yeah, I'd be doing that. If you haven't done that and you think you're just going to go off there and start talking and not, the judge is not going to have any way to connect documentary proof with what you say, I think it slims down your chances of prevailing. And you always want to have the closest chance of 100%. You never can get 100% because you can never, the wild cards are the other person and other things. You want to make it as easy for him to connect the dots and see that you are correct. Because if he doesn't and he awards you, he will be audited, good chance, and overturned. And then you're back in the same boat for another multiple year battle. You could either go to the hearing, maybe if you are going to try to get this together the way I say, assuming you haven't, maybe you have already, Luis, consider alerting the judge's assistant that, I just realized that, I should be organizing this better for, the dogs, organizing this better for, I might have to go close that door, for the judge in a more laid out fashion, like a brief. And we have the hearing on the 9th, and I just didn't realize that that would be be something that would be appropriate. Can we get it adjourned 3 months? Or if we have to show up on the 9th, can I ask the judge, and will he give us more time? I bet you the judge will give you more time. Hold on one second. Hold on, guys. I just want to turn off those dogs by closing the door. If I can figure out how to do this. Well, I can. Oops, hold on. I'm here. Now I'm just turning it back on. Okay. Just close the door, and it's clearly not a noise-proof door, but I think someone's entering the building and they get a little excited. All right. RD is in the house. Luis, I hope that helped. I mean, I know I came down a little hard and fast because you just need to know these things, but I hope some of that helped for what you should do to prepare for hearing. It's what I did, and it worked, but I think I lost 10 years off my life. Just saying. All right. RD says hello from California. Hi, RD. Nice to see you. Eddie Garcia. It's funny. I know an Eddie Garcia in my neighborhood, but I don't think you are here. Good morning, says Eddie. And it's nice to meet you, Eddie. I do happen to have a few questions regarding my son's SSI monthly payments and back pay as well. Eddie says he was just approved and I had to open a dedicated account for him. My question is, with that, am I allowed to purchase a vehicle to transport him to and from his speech therapy and food therapy appointments? Are you buying him the vehicle? Is he going to own it, or are you? I'm not going to be able to give you a definitive answer on that. You could certainly buy things for him, or if you buy a vehicle and it's in your name with your money and you charge him rent for the vehicle access for the pay. There's many ways to skin that cat, but you're only using it for his, if he's paying $500 a month for a car payment that he only goes to the doctor 3 times a month, it might be considered not a really good expense or a good way to use his money to buy him a car he barely ever uses. I don't know. I might be overthinking that, but I would just delve into that a little bit. It's a tough one. And, we don't represent on that stuff. Everything is draws from like here and there reads as things come up. Or if I get a consult and I have to really drill home on it because I'm getting paid to do so. It says, even though he has no physical special needs. All right, hold on. I want to go back up. This is proved I had opened it. My question with that is, am I allowed to purchase a vehicle to transport him to and from his speech therapy and food therapy appointments, even though he has no physical special needs? What do you mean he has no physical special needs? He has, speech therapy and food. Yeah, I would tend to think that would not be, might look like a self-serving expense that you're buying a car for him, but you're the only one driving it and using it. I don't know that would be, no. Think about it. Maybe even call the SSA and speak to somebody, but do not take what they say for gospel, because you can call 3 different times and get 3 different answers. Beth Prince is in the house. Hi, Beth. And she was the first to tell me that she could hear me. I appreciate. Hi, Charity. Nice to meet you also. Beth says, is there a way that claimants can search ALJ hearing rulings that are for specific listings? Not as far as I know. ALJ hearing rulings are not published. They are private. However, Beth, if you go to, say, your circuit court and you want to see what ALJ decisions were, this is going to be hard. You might have to subscribe to Lexis or something. You want to see what circuit court decisions were published in your circuit, and then do a word search for whatever your impairment is. You might find a ALJ case that got its way into the federal court system that happens to be of that impairment. It's not going to be about the impairment, but it's going to be about the law that was used in that case. Yeah, I mean, you could do that. I don't think it's going to help you, to be honest, because that's not really what those things cover in that way. But yeah, ALJ hearing rulings are not public. Your decision is secretly in your SSA account. If you take it out of that private realm and send it up to federal court, which is more of a public place, which is what, a lot of people do. That's how we get our circuit, our federal district court cases. And if they get appealed, our circuit court cases, and it can go up the pipe to the U.S. Supreme Court. But yeah, no, because nobody has my client's ALJ decisions unless my client gave it to them. That's private. That's a private medical business, even though it's combined with the law, right? Hey, Spine Surgery Journey. Good to see you. Spine says, all the epidural injections, primary doctor told me it was causing A1C levels to rise, right? Side effects of all that stuff. Is the A1C levels otherwise being controlled, hopefully? Eddie Garcia says, and can back pay be used for rent? Yes. Your SSI person, assuming it's an adult, right? If he's not paying anything for his shelter, they're going to whack him for in-kind income of $334 or whatever it is this year, because he's getting it for free. He should be paying rent and be under a rental obligation, whether it's verbal or otherwise, but it's good to actually put it in writing so that when they ask, or if they don't believe, you say, no, we have this. And this is true of even people who have not received SSI yet and don't have the cash to pay the rent. Get in that agreement as of immediately, and make it clear that there is a rental for this month, and I am going to loan you the shelter, the value of this shelter that you're supposed to be paying me until such time as you get back on your feet, you recover, or you win the lottery, or you win SSI, or in whatever way you get income. It's got to be one of those unconditional whatever ways, because if not, the person has in-kind income of a third, and they're going to cut down the SSI by a third. And so better that he pay rent and you get that third, right? Than not. I mean, someone's supporting. But by and large, most SSI people, particularly if they can't fend for themselves, would not be able to live very, very well on just the SSI. I mean, some can when they have a certain kind of rent assistance from the government and decent food stamps and utility help. Some people live better than people without, but that's not an automatic thing, and it's probably more the rarity. So it might be a who you know kind of thing. But yes, back pay can be used for back rents. Did he already prevail, Eddie? Because if you had a prior verbal rental, agreement understanding, you're going to want to get that documented as of when did you guys make it, even if you never talked about it again, but it was like, we discussed it. It was definitely an arrangement made. With family, you don't go and talk about it every day. And often you don't write it down. But now's the time that you might want to document that. On so-and-so date, we came to a rental agreement where, Johnny would pay Eddie, who's housing him, $600 a month. That would include room and bathroom and use of kitchen, or, whatever it is. You don't even have to be that specific, I don't think. There is a form too for that. We use the form, we share it to people when they're now under an SSI heading towards a perk, and they need to put in writing that they had this verbal agreement 2 years ago, so that the SSI, when they look at all the months from the 2 years ago when he applied, they can see that there was no income that month because he was under a loaned rental agreement, and the month after and the month after. Because if you don't have that, then the person isn't due the full $900 and some odd dollars. They're only eligible for $600 because they don't have a rental expense. So why should they be getting rental monies from the taxpayers for it if someone's giving it to them? Okay. Also, Eddie says, would I be able to use either his back pay or monthly for sensory equipment such as climbing toys? Is this a baby or is this an adult? I don't know. I think you have a child, right? It sounds like a child. You're talking about little things. His SSI, as long as his basic survival needs are met, can be used for nice things for him, for sure. They can't be for you. That's why I was saying the car is a little problematic. Like, yeah. And the car, I don't want to go too far and in the weeds because I don't want to get it wrong. But, with that whole, like, I'm going to buy a car for myself on my son's back pay. So twice a week he can go to, you have a car now, right, Eddie? And there's Ubers and there's, other things. So buying an entire car, but meanwhile, your son can own a car if it's needed for his thing. So you could buy it for him if he owns it. That's how it won't count if he owns a car. But I'm just concerned about the optics if you buy it for yourself. What's the chance you only use it when you're going to food therapy or speech therapy? All right. And did you say he already won his SSI? Because you said he has no physical problems. So a little bit of speech problem and a little bit of, food therapy. Does he I say this because my son did this. Shove it in and deep. So he's like a chipmunk. And you're afraid he's going to choke every time. Yeah, we had that. And a therapist. Let's see. Divine Cancer, KD. Well, Divine is always good. Cancer, not so much. How you doing there, Divine? Spine Surgery Journey says, is that evidence along with everything else? Oops, let me go and scan you up. Spine surgery, where were you? Yeah, these little scroll ups that I take time with get deleted out of here for the replay that comes out hopefully tomorrow. Spine Surgery Journey says, all the epidural and okay, the A1C. Yeah, well, yeah, of course. You're going to, don't be trying to micromanage whether something's important or not. And you have an attorney too, so you can talk to him. But yeah, everything that's going on with your body, is it going to be pivotal that your A1C went up? Not at all. Unless you have uncontrolled diabetes and your limbs are falling off and all that, maybe it would. But put it all in. You're not supposed to ever cherry pick out anything. I think there's a pretty strict rule on it. The good, the bad, the ugly, and the boring has to go in. And the epidural is certainly relative to your pain, so that's important right there. And yes, let's say the A1C1 rise was significant enough where your doctor was like, you got to get off the epidurals. Now you don't have this pain relief. It is a failed conservative, I think they would call that conservative therapy. And that's always relevant. If every conservative therapy has failed and people are getting less and less options, and sometimes that means surgery as an option, which clearly you already have that journey, right? Given your name. Thank you, Divine. Super, super sweet. I would say it's less advice, but more just information and interacting on the thoughts there and things we see. For advice, you really have to be knowing all the facts of someone's situation, which we can't do here. So just some general information and shares and impressions. Divine is 54 and waiting on a decision. So you had your ALJ hearing, or are you waiting for a determination on initial recon, Divine? Fingers crossed for you either way. Oh, Divine filed in January of 25. You're probably on initial is my guess, right? Possibly recon. Most definitely not ALJ hearing. You haven't had a hearing yet. Eddie Garcia. Also, if you may be able to elaborate and give me some detailed examples of what I can spend it on for him. He is autistic. You can spend it on, it's not, as long as you're spending it on him and you're covering all of his basic needs first, you're pretty good to go. If you were spending it on like crack cocaine for him, probably not so much. Do you see what I'm saying? But recreational, he's autistic. And by the way, speech therapy is not physical exertional, but it's not mental per se. And food therapy, like some of that borders into physical repercussions. I mean, kids can have IBS and these other things which are physical and then can spill over, like the symptoms can affect the exertional and all that. Kids, of course, have a different definition of disabled than us adults, because ours is all about capacity to go back to work or start work. And the kids, of course, we don't have that. Your options are very wide with what you can spend it on for your child. But remember, for him to get SSI, you had to be pretty low income, right? So, I mean, his SSI is not huge, but it's going to be at best like $1,000 a month or something. Maybe you have a stipend, the extra from the state. You can buy him as a parent. Your latitude is tremendous compared to if you were a friend of somebody on SSI. It would be different because they understand parents are going to be providing their children with vacations, time off, going to the zoo, like fun things. They might need the socks and the shoes and all that. So don't be too worried about that. I would just double check about that car business if you're going to buy yourself a car. I would prefer to see you buy yourself a car in your own sphere, your own account, and then you're charging him rents. You're using all his money for, you can document to the extent you even need to, his share of the whatever it is, the rent, or the fact that it covers the overhead. So you're going to be able to use that money to help the overall financial situation in the household that you take care of your child in, which is going to help you buy a new car if that's what you need. So let's say your car is on the brink and you're low income, which is why your child gets SSI, you have a car, but it's going to end. And, you're probably devoting a lot of extra expenses to your child, regardless of SSI and other public, benefits for disabled children. So don't feel, any which way when you, as long as you're putting over the appropriate care for him, that SSI is not scrutinized when it's a parent, because that would be like in your face. But I always say, but do generally keep track, the household expenses, he's part of that household. So he technically enjoys a proportional amount. Hey, Sammy Gordon, nice to meet you. Have you ever seen a case with someone that has Meniere's? I'm soon to turn 62 and it's gotten really bad and treatment and have not helped thinking of. I've never had a solo Meniere's. Are you vertigo and ringing in the ears and all that? And what else are the symptoms? Every single case I've had where there's been Meniere's that's one of many impairments. And it seems like adjudicators are hesitant about vertigo. It's not the easiest symptom, even though to me it's entirely disabling. I guess because the vertigo seems to happen in the privacy of a home, never in a doctor's office. They will, of course, look at what medications are on there, because people with vertigo, that doctors that have found it are going to prescribe them the anti-vertigo medications, and they might be with or without side effects. Those are all the things you want to include. I don't know how old. Oh, you're soon to turn 62. Come on, Sammy. I'm right behind you. We have other impairments. Do the old body chart. Look at every little point of the body and say, is this body part as good as it was when I was 22? When I was 20? Is it fast? Is it as pain-free? Is it as flexible? Is it as strong? Is it as comfortable, pain-free now than it was then? If not, there's some degeneration there. And our aging degeneration counts. It counts for an SS claim, which is wonderful. So think of all those other things. If you're going to apply, Sammy, you want to work up all those other body parts, because you want to get your exertional situation down where you can prove you couldn't be doing a job where you're lifting 30 pounds, right? Because you don't want to be found to be able to do medium work, or else you can't grit out, all right? It's not the only requirement for gritting out, but it's one of the three for you. Contrazy, nice to see you again. Did I see you in the last? I must have just seen you in the last one, because I know that name. I was thinking maybe I saw you on a regular post, but no, I think I said the name out loud, so I must have met you on here before. Nice to see you again. Contrazy says, how long does it take to get your back pay after approval if you have a lawyer? Does having a lawyer help you get it quicker? No. The only time having a lawyer is going to help you get it quicker is if they screw up and it got lost in a cog someplace. We sometimes can be the squeaky wheel, but you can actually be your own squeaky wheel. I would speak to, while your lawyer is still your lawyer, I would talk to him first. But if it's only been a few weeks, probably don't bug him yet. If it's been a month or more, might start thinking about it. The lawyer can do nothing more really than you can do, which is calling and nagging them. If it comes down to like 6 months, long before then, I'd be getting my congressperson involved, right? And you can always call and always use honey, not vinegar. You want to keep the SSA staffer on your side. And if you make them want to hang up on you, they might just do that. So be careful. and respectful and all that, because it can get very frustrating. We just want to scream into the phone. Oh, AFVets, super sticker, thank you. It's all going to that awesome mission. It's really done some pretty cool things since we started this, so that's really cool. All right, let's go down to interacting. So I'm not going to bump into your conversation there, Divine, but I think that's super sweet that you're giving him encouragement. Eddie Garcia says, I would like to add that I do not own or have a vehicle, and we are relying on our extremely nice neighbors who work from home to let us use their car for those appointments he has and school. Thank you. Hey, so if you do buy a vehicle in your name and your son is contributing, your son's SSI is for his overhead. That will therefore mitigate your overhead, and you will have the money you would have used for that part of the overhead to pay a car payment. Just an idea. Talk to somebody who's more of a financial guru, but also maybe a little SSI literate. But him getting SSI helps you be able to better afford your household. And that's the point, because your son is now contributing based on his disability that, keeps people at home. Probably two parents can't be working when you have a disabled child at home. Am I right? Or am I right? Let's see. Christina Egan. Is it Egan or Egan? It looks like Egan. I'm going to say Egan unless you tell me otherwise. Nice to see you, Christina. 52-year-old realtor. I got one of those. He was awesome. Well, we have two. One for a estate sale of a house down in North Carolina. And he was really, really, really good. Good because he was really so just warm and let you make decisions, but would tell you what he thought when you asked, and you could just really trust him and stuff like that. Super, super sweet. If anybody needs his name, he's down by the Mooresville or Statesville area. He's really, really super sweet. That's North Carolina. Post-stroke issues. How do they determine SGA with past incoming commissions this year? Some months 0, some 6K, etc. Man, I'm assuming you're not working at all. You're going to, and I don't want to step out here, show that the money was from the work. You're going to want to pinpoint when that work was from. I know there are some rules when they're going to try to count it in the month it is. So get your documentation really squared away. Like whether you have to do a spreadsheet or whatever, I keep talking about spreadsheets, right, guys? How else you can organize it, I guess. And by the way, I sometimes do a little spreadsheet on a notebook. Sometimes I just like to have a pen in my hand. Looking at the Excel spreadsheet is not my favorite thing. And writing it down gets things more in my head. And then sometimes I'll put them in a spreadsheet. Yeah, I'm assuming there's been no more showing houses, no more doing that stuff. It's literally just receiving the money. Just document that really well. If the 6K were to be deemed countable earnings in the month received, in any event, I don't see how that can be. It would still not be work activity. So it could be a failed work attempt. You're not working besides looking at the deposit, that beautiful deposit, right? I don't think it's going to be a problem for you, assuming you're not working anymore and, you could prove that the house sale occurred, before. But commissions get paid out pretty fast, right? Don't they? So I would think this is not going to be a problem for long. So I wouldn't stress it on it too much. But I would just, keep the proof that was before it was before my stroke or before my alleged onset date when this work was done. And that now I'm not doing any. Okay. It's hard. You might have been self-employed, right? As a realtor from your broker. George Graham. Hey, bud. Long time no see. It's hot here in Punta Gorda, Florida. I bet it is. We actually have a cool day today. I'm up in Pennsylvania, but I'll be in New Jersey in a few days. And I'm really hoping that it's not going to rain. Like, we are really overcast here now, and it did rain a little bit, which I'm okay with. We probably needed it. But if I'm going to be near the beach, and I'm not a beach flyer, and I don't know if my one friend is listening, but I bought myself a really inexpensive metal detector that can go underwater. And when I mean really expensive, like there's really expensive ones like $1,000. And I took the one that everyone buys. That's, teenagers. And they sell like $3,000 a month. I'm like, yeah, because everyone, their mother's beach combing. But I thought, you know what? I'm getting up into that. Even though I won't retire for probably, if my brain stays alive, 15 years, maybe 12 years. I want to start doing things like as if I was a tourist. I've never been able to do that. So it would be cool. I want to start doing those things. So yeah, I'm hoping it should arrive today. Amazon. And my friend who I'm not going to name the person, of course, sent me for my birthday, and I had to spank him because could ill afford it, some little peripherals for if you're going metal detecting. Because I said a couple months ago, I'm going to go buy myself. I'm going to save up. I'm going to buy one of those awesome ones that'll tell you if it's gold down there or practically diamonds or the carats. Or, there's really expensive ones that are like 1,000 and above. And I wasn't even kidding. But I was being a little unrealistic on budget. But for my birthday, he bought me this little sifter. Like, I am so excited. I'm leaving in a couple days, and that's going in my truck for the ride with my new delivery that should be here any moment. And that friend is from Florida too, George. Okay. Divine is sharing some information with some folks. I'm going to pass on that so you guys can continue your conversation. New York, the best. Yes, it was. Oops, did I just say was? I'm sorry. I didn't mean to say that. I'm just kidding. Just the current events. 44 years, apply 2018. Going back to judge for the fourth time. You're 44 years old, New York. That's a hard age, for SSD. You're a youngster in the eyes of the SSA. Denied by the judge every single time, but appeal sent back every time. Just had mental and CE, was just diagnosed with mild neurocognitive disorder. Okay, a lot of people work with mild neurocognitive disorder, so that's not gonna do you at 44. Could feasibly do you if you were older than that or had you really have to go back. You really have to hone in on those physical things and why you cannot do a simple, unskilled, the kind that a mildly neurocognitively disordered person can do, why you can't even do like the lightest and the easiest of those jobs. So that's kind of what you're tasked with figuring out, New York, okay? Okay, New York goes on to say severe sleep apnea. I assume you're on a CPAP or one of those. And fibromyalgia. Check out our fibromyalgia videos, New York. Fibromyalgia is a very difficult diagnosis to prevail on with the SSA. So you're going to probably be leaning on other impairments that might cause the same symptoms as the fibromyalgia. It's an unfair thing, and I go into that quite heavily. In the last month, I think there were 2 videos. I think it was the last month, and on 2 different issues of that, including a Ninth Circuit case that came out. I believe it was an unpublished case, unfortunately, but you should read it if you can. I know you said you're a little cognitively declined there. I do go into it though, so if you want to look at that video, I'm pretty sure it already came out. And then I probably have one from a few years back when an issue on it came up. Fibromyalgia is a tough one. But the lumbar bilateral radiculopathy, that is an objectively diagnosed thing, whereas fibromyalgia is kind of like a ruled out syndrome when they can't find anything else wrong. And a lot of people unfairly think it's all in your head, and that's where the problem comes in. But you've got the bilateral lumbar radiculopathy. That's big. They're gonna peg you at sedentary or light. That's if you've been. Did you say you were declined? Yeah, because you're gonna have trouble proving that you can't even do sedentary, super easy work. How do you prove that? If you are bedridden half the week and you could prove it that it was medically, no choice, that could help. But that's very hard to prove medically. Doctors generally don't come out and say something like that. So you have an uphill battle. Asthma, yeah, that's not going to win it. Migraines, if they occur with regularity, let's say every week, you need to start documenting that. I would maybe keep a journal. How many hours? And when we say migraine, I'm not talking about just a headache that you call a migraine. I'm talking about the one that puts you in bed in a dark room and you're nauseous and you need the lights out and maybe a cool temperature, maybe a compress over your forehead, maybe a bucket because you might feel nauseous. We're talking about migraine, right? And then if you have a migraine, do you have a neurologist, a migraine specializing neurologist? If not, it's hard to take a migraine sufferer seriously if they haven't had them serious enough to feel like they should do that. Depression, anxiety, you have a therapist, you're on medications. And by the way, guys, not all depression and anxiety cases must you hop on a medication. It really is going to be fact specific about what your particular path to disabled is under the law. Sometimes the mere proof that you have it, which would then normally, if you're not going to do medications, and I could totally understand not wanting to do those things, it would be the talk therapy, at least to show that you're having the issues and that you're talking through and trying to gain coping skills to make them not control your life as much as they do. And the reason why they're important is not because it might in and of itself mean you can't work. It might eliminate certain jobs, like the high skilled jobs you need to focus on. If you need to focus to do, you need to be on your toes mentally, because depression and anxiety tends to make us not be able to concentrate fully like we may be used to. And we might not be able to work at a fast mental pace, which a high skilled job that you had before, for instance, might require that you be able to do. So just things to think about. My insurance date, I think he's talking about his DLI, expires at the end of December. Right. So New York, unless you start working something very part-time under SGA, perhaps under TWP to earn those credits. Let's say you earned $700 a month. I can't even do the math off the top of my head. But you need to earn your 4 credits a year to keep your DLI ahead of you. A while back, it could have been where you just had to earn 2 credits. And the credits are, I want to say 800 and something maybe. So $700 a month earning in some easy, accommodated, some job or self-employed where you pay taxes on that 700, that will get you your 4 credits each and every year. Each year, starting today and probably next year, but you'd have to find out what the cost of a credit is. Like I said, I think it's $18.10 or $18.20 right now, but it'll go up if COLA goes up, and you'll want to times that by 4 and earn that the next year. Very part-time, not one that would interfere with your case or anything, or your ability to file. You could do both, but it'll prevent you from losing your insured status, and then you could never file for SSD if you don't have insured status after you already have that period of time adjudicated as a denial. Okay, I never want people to have DLIs that are expired ever. It's like my pet peeve. Luis, hi Luis again, says for 30 years, no problems of any issues, and when he dies, the money went back to him. I have no idea what that means. When he dies, who dies? Someone died already, right? I'm not sure what that's alluding to, Luis. Luis, if you wanted to do a consultation, we have prepaid consultations, and you're welcome to it. I'm trying to give you as much as I can here, not knowing everything, but and this one's cheaper. Gemini to Butterfly. Hi, Gemini. Nice to see you. I have a consultative examination mental on August 22nd and a consultative exam physical September 4th. How long would it take for the disability payments to start? Those things do not decide whether you get disability payments, much less when they start. Gemini, you have to win your case for disability payments to start. So I think what your question should be, and there's really not a firm answer, after September 4th, consultative examination, how long should I expect before I hear from the SSA? And I've said this before, typically the CEs are the last thing before the adjudicator sends it to the medical expert to determine your RFC and then send it back to the adjudicator to make the ultimate decision based on the law. But there are times when the adjudicator knows that, you told them, I just went for a surgery and they need to get those records. So it might not happen that way. It might be where they're still ordering records after your CE. I mean, it really depends on what, every case is kind of dynamic and things can be fluid and change. So it could vary. But historically, usually within a few weeks of a CE, we had the case is closed with a determination for what that's worth. And then whether or not it's a win, of course, fingers crossed for you, Gemini. Hope it is. Divine Cancer, you are so welcome, and I appreciate your kind words. Dimple's in the house. How you feeling, Dimple? How's that recovery going? Beth says, can't wait to hear the stress video. Something every claimant can relate to. I know. And it can be useful to a degree, I think, in all cases, if it's medically represented, of course. My family and 2 adult children are the most good. You have the family. It's always good, right, Divine? She's giving us words of wisdom. Thank you, Divine. Louise says, thank you so much. I appreciate your time and knowledge. You taught me so much. Oh, wow. I'm glad, because I know it's hard here on this venue, of course, for more complicated matters like yours, Louise. Well, thank you for the kind words. I'm glad it was time well spent here. Okay. I appreciate Jake's Custom Parts. Hi, Jake. My son's name is Jake. Any advice on the physical exam in 2 weeks? I need to update this, although not much will have changed, but there might be a few little things I've thought of in the meantime. There is a consultative exam, I believe, playlist, and at least one video in there is on the physical examination and what to expect and what to think about and know before you walk into it. Okay. So I suggest you take a listen at that one. And it's important, before you go, if you know what I mean. Okay. Dimple says, I've checked again with ChatGPT and got a list of recommendations for my rheumatologist to put into my records that would support a disability case. Oh, did the ChatGPT tell you how you're going to convince your rheumatologist not to be offended when you tell him that? Just be careful. I've yet to have my roomie to go over. Well, good luck at it. If you have you might have a rheumatologist that is supportive, not biased, and thinks you should file. And I wouldn't be surprised if you do. Most people don't, though. So that's why I have those other videos about, you don't always want to tell your doctor, hey, I want you to help me get disability. It might not go very well for you. It might actually cause damages to your case. Hey, Dandelions, long time no see, bud. The texts on screen are really hard to read. Can you zoom up? Are you on your phone? I can't speak to that. It looks the same for me as at any other time. You're talking about when I put up, like, I have you up there right now, Dandy? Dandelions. The text on screen are really hard to read. Can you see that? Is that what you're talking about? Contrazy says, so it has been 2 months since my second ALJ hearing. Does an ALJ usually already have an idea what the decision would be? I know I have to be calm and wait, but this has been 200 plus days from the first one. Oh my gosh, you poor thing. Well, everyone has their theories. So I'll tell you what the theory of some is, that often the ALJ does have an idea of what the decision would be, because by and large, they have reviewed the case. Their attorney advisors have reviewed. They may have reviewed it directly. They may have synopses from their helpers. Who knows? A thought process has begun. But I believe technically they would be in trouble if they ever said they made a decision before the hearing, because the hearing is part of the evidence. And you're not allowed to make a decision before you consider all of the evidence. You can't predispose yourself, supposedly. But I don't really know how you can actually kind of not. I mean, humans have human brains. And if you read 90% of a case, you're going to have an idea. Now, I will say this. I've been to a hearing where, and it was a young person, and it's always this kind of cases you're supposed to lose. After we were in the hearing, this is not the only time this has happened with two different young people. I think it's at least twice, where the judge said, oh, I see this case completely different than I thought I would. And we prevailed on both. So the person showing up, it was more evident than what's on paper, which I thought the paper was pretty strong. But when it's young people, you almost have to be in a coma and bedridden, or glued to a wheelchair. It's really, really hard, or institutionalized or something. And I'm saying that generally, guys. Obviously, that's not the case, but most people will find that to be the case, because most of them are going to be denied. So that's how astute and detailed and durational the other evidence, when that is not the case, when those really severe limitations don't exist, the evidence has to be. It is almost an indefeatable mountain. And it takes a lot of work by the clients as well as the team to get it all laid out, get the evidence in, that's the client, and get it all laid out. And the representative's job, I think, is to advise the client on, you need to do this, this, and this for a stronger case. Those that have known me a long time know that I am the nag hag with my clients. And once in a blue moon, every year or so, you get a client who can't take it and gets mad and thinks it's rude and will hightail it. And that's fine. The alternative is letting down 99% of the people and not doing it. And a warm, coddly suggestion is not going to be followed, because it's warm, coddly, and not driven home as, you're screwing your case if you don't do this. So we kind of spell it out really objectively, a little curtly, I guess, sometimes, but it's all so the person has the most opportunity to help themselves and help us help them. So anywho, I digress. Contrazy, hang in there. Second hearing. Ooh, so you had a remand, right? I don't remember the facts, but I think we shared them. You shared them before, right? Virginia Gomez, nice to see you. Good morning to you too. Can the appeals council overrule the denial on the spot, or do they have to send it back for an ALJ hearing again? If they overturn the decision, what happens after that? There is an instance, they do have reversals and therefore an award. Like, it's not just a remand for the judge to redo something he may have missed, a particular step or something. The last waterfall chart I saw, which was a couple years ago, I know I got to get a new one. I'm curious if anything's changed. I think it was, if the overall remands were 15%, reversals might be 1%. I think 1 or 1.5. So they are very rare. I think I've had one. And I suspect they do not occur due to discretionary decisions by the AC. It is when they take everything the judge found as gospel and they find that, like, for instance, in my case, the client was, I want to say, going to be 52 months after the hearing. And although I knew he was disabled in his 40s, the judge didn't want to and didn't award him. However, maybe it was 2 months after the decision, I am not sure. I can't recall. But the AC, we appealed, of course, to the AC, and the AC reversed it and awarded, because given the RFC that the judge decided was my client's and he applied it to a 49-year-old, when applied to a 50-year-old, he won because of that rule change when he hit 50. So he didn't get it all the way back to when, which would have been maybe 2 years before. And this was an SSI case only. Yeah, that was a complete reversal, because assuming all the factual findings of the judge to be respected. They can't go and make a discretionary call otherwise, I don't think. I think they remand it when there is a legal reason. Like, I'm sorry, they reverse it when, okay, assuming that everything that we'll agree with the judge's findings, because, we can't just overturn his discretion. We have to send it back to him because he made a legal boo-boo. He forgot something legally. Here they're saying he didn't forget something legally. He did all the steps, but at the age the client now is at 50, that finding that he made means legally disabled, because now he fits into the rule of being disabled at 50. So that happens, but I don't think they're going to say, we think he's sedentary, not light, and we're going to award him. I don't think you're going to see that. Don't hold me to it, though. I don't see a rule, but because the appeals council has limited jurisdiction to only do certain things, that's why I say that. They don't really have, generally, discretion to find that the judge doesn't find it persuasive when the claimant testified to only being able to walk 5 feet, and so that doesn't give that any weight or very little weight. I don't think the AC can say, we think he was pretty credible. I don't think they can do that. They don't have a visual of the person in front of them. They can't see the hearing. They can hear the audio, but that's it. So I don't think they replace their judge's discretion for their own. They only look for concrete objective failures by the judge to follow the steps he needed to follow. If that makes sense. JRP 10. Hi, JR. Are my chances higher with attorney? I have an appointment with the judge. You're asking me? What do you think I'm going to say? Of course they are. However, it's hard to get an attorney. This is like the eve of hearing for you. Attorneys can most affect the case when they're brought in early, and they can advise you on things you need to be doing to build the evidence that they can then use to create the arguments and tie the new evidence that they have because you followed directions to the law. They know what evidence will work under this particular law and what won't. And so if you come in and you're getting an attorney 2 months before your hearing, he's not even going to be able to get a copy of your file until the week before the hearing. That's how slow, things can be. He has to first review your case if he wants to take it. Then he has to get the SSA to process his 1696. Then he has to get into the electronic file and download your whole file. Carve out time from his other clients to review your entire medical file and your vocational profile, all the A, B, D, E, F, sections of the file, and prepare you and then figure out where is he lacking and what advice should he be done. Oh, he should be going to get MRI. Well, you can't really get MRIs on a dime. You can't often get an orthopedist referral on a dime. So all these pieces of things that you should have been doing, and I'm saying you as a general, obviously not you, JR, you presumably have been doing it. So the attorney is limited. I mean, yeah, he can throw in some cross-examination at hearing with a vocational expert, and he can make sure certain evidence is you testify to at hearing, but the real power is the building it slowly and strongly from the start. So it's almost like there's no such thing as an airtight case. There's no 100% surefire win, but if you can get it as close to 100% as possible, the chances of yourself losing become smaller and smaller, and that's what you want. So it would have been good if you had gotten one before, but there might be some that take them. I generally do not, only because I put in a ton of time, and my time is very, very managed so that every single case gets the full hilt. So if you sneak in another 100 hours for a newbie, it's going to have to come from somebody. All right. Next, we got Eddie. If my son is a minor, can I still put the car in his name? You don't have to talk about, so certainly you can. In terms of SSA, they're not the car Nazis, but just another idea, Eddie. I don't know why a child can't own any kind of asset, except maybe a firearm. What if a child inherits a classic vehicle from a grandparent, a 210, I don't know, what existed then, guys? Come on, all you car people. Do you think they're going to say, nah, you can't inherit that? We're going to have to sell it to a stranger. No, what if that child, so a child can own things. It might have to be, held in trust by somebody else. And that's what I was just thinking. That just popped into my head, Eddie. If you have a trust fund for him, and by the way, this might be a good thing to do anyway, a special needs trust for him. If that special needs trust owns the vehicle, and the vehicle, he is the beneficiary, and the vehicle could be used. This is a special needs trust is a very specific kind of attorney. So you're going to, I did one 20 years ago, and I'm not going to relearn it. And it wasn't for a child. So look into that special needs trust. Could you then have the car bought with his money And assuming, of course, you're meeting all his needs, which I know you are, Eddie, in the special needs trust, so that assets of a special needs trust go, I think they have to be forfeited later. I'm not sure. You got to get into the S&T stuff. But I don't know why a child can't have a asset like that in his name. He could own gold bars. He can have a child savings account. Now he can't because of the SSI. But remember, the car is a non-counted asset if he needs it for transporting, getting to, So that's where I feel like that workaround is. But look at a special needs trust anyway. I mean, eventually the car is going to depreciate to nothing, right? So, and it won't be going to the state or Medicaid or there's all those rules about you can keep that money so he can get nice things throughout his life, and it's from a special needs trust where he has no control over it. And it's a very particular kind of trust. But there are rules. It might even just be the pools ones. I don't know. I haven't been following it. I gotta restudy that. But I don't represent on that, so that's why I don't make it my mainstay. It never has bearing on me proving disability for my clients. It's an after fact, really. Have you ever seen, this is Sammy Gordon. Hi, Sammy again. Have you ever seen a case with someone that has Meniere's? Didn't we already do this? Did I bounce up? No, I didn't. You probably just typed it twice. All right. I don't know why that came up, but you probably just typed it twice, Sammy, right? And I'm reading it. I'm realizing. Yesenia Ward. How are you, Yesenia? Thanks for stopping in. If on SSDI and you do foster care, will that flag a CDR? Well, it's an activity. So I don't think it'll flag a CDR. I mean, parents are on SSDI and they have kids. Do you have 10 kids? Are you able to babysit 10 kids? You know what I mean? Like when you do a function report and you say, I cook for 10 kids, so it's all going to be what you're doing. Sometimes you can be fostering older kids and they can pour their own cereal, or you can pour cereal. I mean, you're still disabled from working. I don't think that's a flag. I don't. That would be very probably in and of itself. If your activities are, like I said, when I took him skiing, because I'm a foster parent, you need to learn how to ski. That would say that you don't have the bad back you thought you did. So it's all going to go down to activities. The mere fact of foster care, I don't think would be so. Particularly if there's another adult in the household. Do you have a spouse? Just saying. Fact sensitive, but they're not going to discourage disabled people from being great parents, particularly when we need them in the foster care scenario. Sammy Gordon went through kidney cancer in 2020, and ever since I've gotten worse. Ouch. Hope you're okay with that, Sammy. So Sammy, it sounds like you're still working. Also, my employer has put me off for the last 2 weeks. I doubt I'll be able to go back. All right, so you might have a work end date finally. Were you working SGA prior to that? So that's why you haven't filed, you said, right? New York says that he or she takes Botox injections for migraines and Ubrevy. Okay, so you're on heavy duty migraine meds. I'd say that is like I don't want to say the gold standard because it's unfortunate. It's bad for you, but good for your case. Migraines, you definitely want to have that in there. For Botox, you probably have a migraine specialist, so you're doing good there. And I know you're young. You said 44, right? If I'm remembering correctly, what we were just talking about. One thing about migraines, guys, Botox injection, I don't think insurance approves them unless it is convinced that there are 15 migraine days a month. And we're not talking when someone goes to their doctor, they drive 45 minutes to their doctor and they go in and they're like, oh, doctor, I have such a migraine right now. And the doctor is rolling his eyes in his head going, she clearly has a headache and not a migraine. And it's not even that bad because she drove 45 minutes. Be careful how you word things, guys. Right? Obviously with the Botox injections, that's not you, right? New York. And you take the other medication. Consider keeping a journal if you haven't already. Where you can do one about an onset of a migraine you can have it 2 separate entries. The migraines that you have to take your medicine to try to abort it and it successfully does and you don't land yourself in bed, if those even happen to you, and maybe they do with now that you have a Botox, and the ones that nothing help it and you're still going to be in bed. I assume those still happen to you. Maybe not. Maybe the Botox is preventing those, in which case then the migraines might not interfere with all jobs, just the ones with flashing lights and loud noises. But those kind of pieces of evidence, I always have to emphasize, I find that SSA doesn't embrace with a level of seriousness migraines. And ALJ will find it to be a severe impairment. And then they will have no missed days of work discussed. And I'm actually appealing one right now on other issues as well, but that one is going to be one of them. How can you say it's a severe migraine impairment and have it listed under the ones that were found and then not addressed any lost time from work? Because enough lost time from work, I always get the VE to talk about how much lost time would mean no jobs available. Jobs have a certain tolerance for absenteeism, tardyism, leaving early, and otherwise being off task, like taking breaks that are not permitted. So, when a judge says it's a serious migraine impairment, severe, and then still gives you a light RFC and never mentions absenteeism. I find that to be a lack of reality, particularly when the records are replete with 4 to 5 migraines a month, lasting 4 hours to 18 hours. Now, sometimes the doctors don't articulate very well, New York, so that's why I suggest the journal, so that whatever's in there can be fortified by your own personal journal, going back months and months from, start it now if you haven't done it, and literally just put, once you're up from the migraine, of course, not in the middle of the migraine, but make it a priority that when you're up from the migraine, able to get up, document how long you were bedridden for. And sometimes I suggest any of the peripherals like nausea, vomiting. When I say down, I would do the bedridden ones as one kind, and then the ones that are getting bad, you feel it coming on, but you're able to abort it. You're not going to be able to do high concentration while it's coming on like that, but you don't end up in bed for a day or 4 hours or whatever. Keep a journal, and then I would also perhaps on a monthly basis submit the journal page to your doctor. If it can get in your medical records and you do it in real time, that's good. I think that might be even better than submitting them separately to the ALJ, although I've done that. That's what I would do to help substantiate what is otherwise almost like, I don't want to say it's, I guess I could say it's almost treated as poorly as fibromyalgia is, because nobody has a migraine in front of people because they're holed up in their room with a puke bucket. So, but, and how bad it is, how often it is, and the duration and those symptoms that go with it, make sure those are reported at every visit. I would even say if your migraine doctor is in a portal, the patient portal, every time you have one that puts you in bed, maybe shoot over a message, say, just to keep my migraine history documented here, doc. Yesterday I had a migraine and I was in bed for 7 hours. And then the medication helped get rid of it. But you were in bed for 7 hours. Those are 7 hours you couldn't be working if you were at a job. So that's where that can come in. And New York also says he or she uses a cane. Is the cane, okay, so something about canes. You guys have heard me say this before. If the cane is not prescribed, an ALJ is free to say it is not medically necessary. It's just that you feel like using it, kind of like a headset or, if he's inclined to deny. If it is medically prescribed, even if you go and buy it at CVS and don't buy it through your prescription, but if that prescription, it has been medically prescribed, that means it's medically necessary for you, which implies that there's either instability with walking and you need it, and one hand won't be available while you're walking, or you might need it for both walking and standing, in which case, not only can you not use 2 hands to carry something when you're walking, but you couldn't use your 2 hands when standing at a workbench because you need to hold one hand on the cane or on the table, and you would be a one-handed job. That will eliminate a ton of those simple, unskilled jobs. Small parts assembly. Karen says, hi, Karen, good to see you again. And your smiling face. She says, my CE said I basically can't work. Mighty nice of him. I have to use a rollator inside and outside my home. And the big thing is, if that rollator has been prescribed by your orthopedist or specialist, as opposed to you just deciding you need one, a medical professional said you needed one, that's very good evidence. My balance is very bad. I can't stand up or sit up long because of my pain. Okay, great. CE, that's awesome. Judge is going to see whether that rollator is prescribed or not. If you just bought it because you knew you needed it, and I have no doubt you do if you say you do, but that's not the standard of the law, what I think, right? Ask your professional, your medical professional, the specialist, preferably, if not your primary care, to prescribe it to you. And just say, listen, for insurance purposes. But you don't want them to really repeat that. But it's like, can you prescribe me a rollator? That way I might get it paid by insurance, even that. And then you'll have a prescription in the record. That means it's medically, necessary. And that's a big difference in the eyes of the law. Medically necessary versus client wants it. I mean, because you have people who want things all the time that they don't necessarily need, but they want. Hello, Dimple. Dimple says, I'm afraid of that causing damage to my case. I'm having serious vision problems concerning my current employer. I can't hardly see myself. You're so funny. Oh my God, I'm reading that like I'm thinking you have a blindness problem. Come on. She can hardly see myself. You are so funny. Has she got a sense of humor or what? You're the best. That really gave me a good laugh. Thank you. A vision problem. I seriously can't see myself going back to work with that employer. I hear you. Now, Shub, that is very generous. Shub just donated $20 to the 1% mission. That is so, you already did that. Remember? Just in case you have a memory problem, I feel I must disclose that you did that like a week or two ago, Shub. So in case you didn't think you did, and that's why you're being that generous, again, I ethically feel I must say that, but I do appreciate it. And even if you need to reverse it because you forgot you did it the other one, I totally understand. Very sweet. Very, very kind. Glamour girl. Hello, Attorney Joy. What to expect when a claimant goes to a consultative? I'm sorry, I'm still laughing at Dimple. That's so funny. Hello, Attorney Joy. What to expect when a claimant goes to a CE 2 months after knee replacement surgery? Ooh, are you going? Well, they're going to presumably, I assume the CE, is it a CE for physical? They're going to probably check out your knee, see if you can do all those deep knee bends and all those other things they make you do. Heel to toe, all that business, standing on one leg. That's if it's physical. If it's mental, obviously it has no bearing. Be sure if your knee is not 100%, it's never usually 100% shortly after surgery, right? It takes time. I don't know if you've had physical therapy yet, but if it's not 100%, even if it's well healed and is going as well as can be expected and is great, you still want to make sure it's clear whether it still hurts, whether it still swells. You're whatever the limits are with that knee, walking, standing, crouching, kneeling, all that, because you don't want it to be left kind of in a vacuum where the supposition is, well, she had surgery, all good. She could do a late job. Because remember, I don't know what your vocational profile is, Glamour, but the knees can have a big impact on your exertional level because they can dictate whether you can be on your feet 6 to 8 hours, which means you could do a light job, assuming you can also lift up to 20 pounds. So, it can also define whether some people with bad knees can't do a sedentary job because the knees get really inflamed with the bent position of sitting or being in one position for hours or 45 minutes. Shub says, thanks for sharing your wealth of information weekly. Oh, it is my pleasure. Wednesdays are my favorite day of the week. Aside from the fact that my husband isn't here, excluding that always dampens my weekdays. However, being here lifts it up. I'm probably going to be fired shortly after returning anyway. Unable to keep up with the demands they have set. Off-task time is outside of the limits due to having to move around. Okay, I don't know if we discussed this, Dimple. Maybe we have. But if you've had any tips or warnings about being too slow or taking too much time off, hopefully they're emailed to you or otherwise documented. Before you leave your job, print those out or forward them to yourself or however you do it and keep them, particularly post-surgery, because it shows that the surgery didn't do enough to help you be able to do that job. And remember, you need to prove you can't do that job, the one that you've been doing. So something's going to have to show, right? So the warnings from them, if you can substantiate that with documentation, could be really good as a pretty objective. It's not medical. It's purely from an objective person, though, your employer who has no interest in, being dishonest, he has nothing to gain. AF Vet is giving some advice to Sammy. That's cool. You guys can see that, so I don't need to put them up, and I'm not going to interfere with the conversation. Glama says, claimant is 51 with other severe impairments. Yeah, I'm just scrolling up here, Glama. Yeah, 51, you got the benefit of, the least helpful grid, but it is mountains away from being under 50, which has no helpful rules at all on behalf of claimants. So, you have a fighting chance. Otherwise, you probably wouldn't. Keep up the good fight. I don't know where you're at in it. Hopefully you have an attorney or not attorney rep, just someone who, does the job well. Eddie Garcia, you're very welcome. Virginia Gomez. Okay, we're almost at the 2-hour mark, guys. Virginia says, question number 2. Question, why would my attorney disagree with ALJ decision and wants appeals counsel to relook? I'm 52 from California. It's been 4 months in appeals counsel. Is that good or bad? Appeals counsel is very slow. I've seen them as fast as 2 months. I've seen them as slow as 18 months. It really depends on how many cases they have in and how many people they have reviewing them. It's usually a panel, I think, of 3. I think. Why would your attorney disagree with the ALJ decision? Did you disagree with the ALJ decision? I mean, you said you're disabled and the ALJ said you weren't. So I think, Virginia, you disagree too. Your attorney filed for appeals counsel. He probably thinks that the ALJ didn't do something enough to the level he should have done it, and that rose to a misstep. Now, the appeals counsel does reject most appeals counsel appeals. However, not all. And we get some that don't. And the difference to you is that if you can get a remand back to the judge, I think a lot of remands, well, almost always we get a win after the remand. That doesn't mean all people get that, but we happen to be fortunate with that. When you remand it back to the judge, and if you prevail, you've got all those back benefits that you originally were hoping for. Whereas if you skip the appeals counsel because you want the opportunity to refile right away, which you can't do if you appeal to the appeals counsel, you give up. You're saying, all right, I'm going to accept that judge's thing. And now you have a whole new set of evidence you have to develop because that other evidence described a non-disabled person. So that is not going to define you as disabled on your second application because you accepted it. You know, it became carved in stone by the ALJ because you didn't appeal it. So it might, you know, you could still lose appeals counsel and then you will be refiling like you would anyway. And you're going to have the new time frame. So hopefully your DLI is hanging in there. It could also be where you don't have, if your date last insured is in the past, you had no choice but to file for appeals counsel or entirely give up and walk away. That would be your only option was appeals counsel. So I don't know what your situation is, but I'm sure your attorney thought it out. If he thought it was a really difficult or near impossible, let's say you were at 49 and you got denied, he probably might not have done the appeals counsel unless he had to because you have no more DLI. He might have said the chance of them overturning the discretion of the judge on a 45 slim. It's actually kind of slim at 52 too, but not as much. So, and yeah, you know, I don't know the details of your case, but I'm sure your attorney had a good reason. And the appeals counsel shouldn't hurt you in any way other than delaying a new filing if you have to, because you should be able to file and use the appeals counsel filing date as your protective filing, so long as you file your new case, if you have to do a new case within 60 days, or might be a little longer, that appeals counsel denial. So you can, like, you don't necessarily burn that whole year up sitting there like, now it's like I'm scrolling benefits off because I can't even file. That shouldn't happen generally. All right, where am I at here? It's fine. Is it fine? Okay, this is kind of funny. It's fine. Breathe. Is that your name, or is it's fine breath? You have the E at the end, so I think it's fine breathe, and it's almost like you're telling people it's fine, just breathe. Which one is it? That one? Okay. It's fine says, hi, approved after 5 months. Awesome. Lawyer gets 25%. He filed online app only. That's the only kind there is, my dear. Well, put it this way, you don't file two. You file online, which is the preferred way that the SSA prefers to see the claimants do it. You don't file on paper too. You can't file twice. Only when I called him after not hearing from him for 6 months. He never helped, warned, or advised on forms, etc. I have a not very old video, it's fine, arguing against a contingent fee that your attorney or non-attorney rep gets. First of all, he filed the application online. You asked him to work for you for 25% contingent benefits and asked that you wanted that agreement so that you did not have to pay him anything, even if he worked like a slave or had to for 5 years, and then you didn't get any back benefits or you lost. And you asked him to agree not to charge you for all those dozens of hours he would have worked. And he said, yes, I'll do that because I think I can get you to win. And if I don't, I'll eat it. I think people forget about that part of the agreement. And the SSA designed this so that every claimant who has a reasonable chance of winning, if it's properly worked up at least, can afford, so that money will never be the issue why someone can't get an attorney. The attorneys eat it if they don't pull the weight. Your attorney apparently pulled the weight, whatever that weight was required. I mean, don't get me wrong. I do not agree with not advising on forms. In fact, everybody here knows what I do with forms of my clients, and I do it for non-clients too. If they do a consult, we 200% advise on forms. And we remind people of things that they're forgetting to mention, that we see from a lot of the data we collect from them for that purpose. So we know so much about them before those forms are even due. And then we help them put them in a typed fashion and get them submitted. We do that. They provide the information. We help get it to the SSA in a format that is most helpful to their case and explains what they're trying to say, and also to make sure they understand the questions and what a particular answer would mean or not mean. So I don't agree with the attorneys that don't provide that service. However, as far as I know, there's no law saying they have to. And whether their bar association would say otherwise, I don't know, because this is federal and it's never come up. I just feel that our duty is to do this. Why am I representing the person if I'm not making sure I have my eyeball on every single piece of, they're not even allowed to talk to the SSA or the DDS. I say allowed, I'm not their master, but they know my rule for my clients, if we're going to work well together, is that they don't. And they screw up all the time. I mean, they forget and they pick up the phone by accident and it's the SSA, what are they going to do? I totally get it. There's no hard feelings, but I would say, you got to be careful because there's going to be some trick questions in there at times. I don't want them talking to them. They never send anything in aside from like the attestation to get that application process that they sign and send in after I've looked at it. Nothing else. We actually submit everything. We do it the electronic way. So we know it's there. We can see it's up there. We know it got in. When you fax things in, you have no way of knowing if they got it. You have a fax confirm, but you don't see it up there. Although now, and I just did a little brief video on this, you can submit anything to the adjudicator once you get it up there. Just so you know, guys, you can submit medicals, you pro se people. Okay. So I just got this confirmed. I know it came out in June and I hadn't reported on it, but I just did a little ditty on it. And I don't think it's even been queued up yet. I just did it. I think it was this morning or last night. Can you believe I mixed up the two? So I am not a proponent of fighting a fee. And you could say, well, that's because you're an attorney and you want a fee. Totally true. Totally true. It's fine. But this is what contingent is about. It's like insurance. When you buy insurance, hoping to goodness that you do not get in a car accident, and then you don't get in the car accident, are you like, I think that car insurance company shouldn't be able to have charged me for those premiums because it turns out I didn't get in the accident. I want that money back. I don't think I should have paid it. It shouldn't be a bill. No, because it was like insurance. And that is what a contingent fee agreement kind of is. The attorney is the only one that is going to come up short in the end because they can do all this work and get not paid. Let's say you sabotage your own case and he put in all that work, and this happens. It's not as infrequent as you think. He still doesn't get paid, and he put in he or she put in the legitimate time, paid staff to put in time for you, out of pocket monies, and I hear a dog making a ruckus out there. Oh no, it's a child. And when I say child, guys, they're like 17, I think. Yeah. What else can I say about that? He filed the online app. He had your data. He got it from you. Obviously, I don't know how he did that. Did he just do it with you on the phone? We don't do it that way. We get everything in writing, so we have it all to consider and look at and think if we need more clarification on this. Ours is a bit of a process, but they come out stellar as a result. That's why there's a lot of initial wins and recon wins. And of course, we do have to go to hearing, but we really try not to. I'm just looking at your question here more. So he didn't file for 6 months. Now, I don't know why that is. I don't know what the parameters of your case are. Sometimes the best time to file is not the second you left work. Then you're almost guaranteeing yourself a denial on initial. And it looks like here you got the award on initial. And it's very possible, I'm just saying possible, I don't know the facts of your case, that had he filed within a month of you coming to him, you would have lost that initial. And you would have had to file for reconsideration. And because reconsiderations are often considered a rubber stamp on initial, particularly if you don't have a lot of more stuff going on, and you would have gone to hearing. And you would be in the stress position of your case a year and a half from now. You see what I'm saying? So him waiting 6 months, now I think he should have discussed it with you. I discuss it with people all the time when I think it's something to be concerned about. And it might not be, there's some cases it's a total concern. It's like, I can guarantee you're going to lose an initial if you do this. Other cases, I'm like, it's possible you could still win on initial if we file now. But your chances will be increased, I think, if you wait 3 or 4 months. We'll get everything all ready to bang out in 3 to 4 months. But the SSA won't have their grubby little minds looking at I don't mean grubby, I'm sorry, looking at your medicals that don't yet exist because they're 4 months earlier. They're only looking at the medicals that existed while you were still working, in which case you were not disabled, only impaired. And they're going to, even the next month or two, they're going to be like, yeah, well, her medicals are the exact same as they were before when she was still working. They now have kind of if not an emotional, and otherwise basis on which to deny. It also, separate and aside from that whole optic, is the 12-month duration rule. You don't have to have had 12 months pass. I'm really fuzzing in and out here, aren't I? Woo! I feel like a ghost. You don't have to have passed the 12 months to be found disabled. However, the medical evidence has to be clear that you are disabled and it will last at least 12 months after you stopped working. So there's durational denials all the time. And of course you appeal them, and then then it's not 12 months. And then you hope that 12 months was the only reason it wasn't, that your evidence didn't meet all their check boxes. And then you have to go to hearing. You can avoid a lot of that if both the optic of not having differing evidence right after you stopped working, because that takes some months to develop, but also the 12-month durational, because by the time you file, say at month, let's say it's 4 months after you stopped working, you file. And that also gives you good time to do good solid data to go into all the application and the function report that's going to come up and the work history report and possibly a pain report and a bunch of other report demands that they're going to make. So you can use those 4 months very wisely, but you're now that closer to, by the time the adjudicator's really getting into it and ordering your records and all this stuff, you're probably now at month 6 or 7, and now you're breathing down the 12 months. So that cannot be an issue at some point. They can still deny you and say, oh, we find you could do light work. But the duration argument is off the table and the optic is off the table. So they have to just do it purely on categorizing you, which is their call, but is what you also appeal. So just saying about the 6-month delay in filing, that could have been his reasoning. I don't know. Clearly didn't discuss it with you. That was wrong. Attorneys have a notorious, this is from back in my non-SSD days, notorious reputation. And back then, at least, it was the biggest reason, as I was always taught in ethics classes, for client complaints to the Bar Association about a lawyer. Failure to communicate, not returning calls, not returning emails, whatever. It's frustrating. And it's the easiest thing to overcome. I'm a solo practitioner and I can manage not just communications with my clients, and I have a full caseload, but I don't make it overfull. Everybody knows I have my wait lists in certain areas because I'm not going to jeopardize any of my clients' case to take on a volume that would be irresponsible. Like I do know some people do, but we communicate with non-clients as well because we have a really robust communication system. And that's thanks to the portal I have. It's a case portal we invest in, and it's worth its weight in gold. The clients love it. Even the clients who are not techies and are like, oh, I have to go into a portal. I'm like, you can do it. Because they can even do it from their cell phone. But it's a shame he doesn't do that, because even just saying, I got your message, and that's not something you have to worry about, just anything to let you know that representative has not been hit by a truck at the very least would be nice. So I don't agree with that kind of practice policy, the way he practices, but it doesn't mean he didn't do his job. He got you to win. And when you say forms, I'm assuming you mean the function report and the work history report, but you asked him to get you to win, and he did whatever had to be done to get you to win. I mean, he did. And you asked him to also, if it goes sideways for whatever reason, including if you, God forbid, you passed away, there would be no benefits, and he could have done a ton of work. You know what I mean? You asked him to not charge you if you don't win, and he agreed. So I'm just saying, you guys gotta understand how contingent agreements work. And I will say, Social Security disability is an underpaid attorney profession. It should be for the attorneys that have the right mindset for it, and I think many do not. I think the non-communicado ones need to get their shit together. And that's wrong. SSD clients are a special set of people, and we know that. So you have to have communication. Sometimes you have to have tough communication if they're not following directions or being stubborn about something or trying to be the boss. I get tough. Some clients won't like it. Some will succumb to it and then be glad they did. And some will say, I can't take it. You're mean. They'll go away. And that's fine. I can take that can't take it. And that's fine. And I want them to have someone that is more coddling if they need it. Everyone's got different styles. I don't like the non-communicado one. And it is actually an ethics violation in probably all 50 states. Just saying. But I still don't think, I'm still against fighting the fee when you got the win. I always say, take it with grace. Just like I take a win when I win for my client and I'm going to get no fee. I don't even file a fee petition because my clients aren't millionaires. I could go after a fee, but I don't. I look at it as accept the no fee with grace and be super happy that your client won and you just helped a human being's life be less stressful, have money coming in, have Medicare. I mean, I think it's huge results. And that, I want to say warm, fuzzy feeling. It's something I can even think about a year later with some people. And when I'm feeling sorry for myself about something, I could say, oh yeah, that was great. And I'm so glad that happened, and et cetera, et cetera. But I think, a client could do the same when I think he should have only gotten 2,000, but he got 4. it was a contingent agreement and you agreed to that percentage rate. So reneging on it is kind of distasteful, and I don't think it's acting with grace at all. If somebody cares about acting with grace, I'm not saying you do or don't, Anyway, that's my thoughts on that, guys. Inferno says, how long for international CDR review? International? I'm assuming it's not at a different rate, but I have not looked that up. I assume it's in the same kit and caboodle as everybody else. So how would I know what your CDR is? No idea. I'd have to know your case. I'd have to see your CDR diary date, but you can go and ask for your CDR diary rate if you wish. He says he did just have a CDR transferred because my address is no longer in the USA. Well, there you go. Sounds like you're in a CDR. So are you asking how long it takes? That will depend on how fast things get to them. You're going to want to make sure they get everything they need, because if the evidence isn't coming in that you are still disabled, the presumption might be that you're not. So hopefully you are vigorously going to your doctors in your new abode, in your new country, and make sure those medical records are getting to the SSA or the DDS adjudicator, and make sure they are legible. And not necessarily they have to be in English, but I wouldn't be surprised if it might be helpful to you if they're in English. So if you need to get a translator, consider doing it. I mean, we live out of country. We're trying to get something from a different country now, the USA. We have to kind of meet their protocol. I don't know how good whatever your connection is. I know some people have to actually leave. Like I have, who was it that had to go from one country over to Paris? I don't know. I mean, I have my very limited share of out of country claimants, move to another country for affordability purposes while they're fighting their claim. It's a totally understandable thing some people have to do. It's unfortunate, but I do get it. Not everybody has family they could stay with or get help from. So you just got an email from Baltimore saying that my claim has been brought to this office. Which office? Baltimore? So it is in the US. I would probably try to make sure that those records are legible if you have to get records. And the time frames, CDRs, they don't really have a time frame, as far as I know. It's fine, says, because I don't think he earned what he is getting. I probably commented all this after you put this, right? By the way, your videos are the only reason I knew how to fill out the work history, function reports, etc. Oh, that's great. I'm so glad. Those are the first things I ever put up on any kind of video, which was just for my clients at first. And then to make it easier for them to reach them, since some of them couldn't download them, they went to YouTube. Well, first they went to Rumble, then they went to YouTube. It's been so nice to hear from people that are like, I use those to do. That's really great. I do add to them at times. I think I just did one for the work history about stooping, the forgotten postural that everyone forgets about. But anyway, I think it's fine. You heard my spiel probably that I put in after you wrote this, before I saw this next post. But that's my take on it. Remember, if people fight, the attorney might have a case that went faster. The cases in general, most they don't get paid enough on. They don't get a full attorney rate. It's kind of, technically I look at it as like a labor of love type of thing. But if the good ones that actually pay a decent wage, like maybe yours is, I don't know what the end up wage is, and I don't know what hours he put in, were to be taken away, all you had is the ones that aren't paying, even though the person worked their butt off. And guess what? Every representative quits. And now nobody gets an attorney. Just saying. When we had, I'll give you an unrelated example. Early on in my years of doing this, and I've been doing this for over 20 years now, the attorney rate was $6,000. I want to say 2000, was it 2009? It started at 6,000. I started before then when it was like 5,300, but that $6,000 fee cap, which is now 9,200, stayed for 13 years. It's fine. We didn't get a COLA. Inflation did what it did. Social Security benefits, of which, you base back then, those things went up quite a bit. And our cap stayed at 6,000. And 6,000, as you can imagine, was worth far less 13 years later. And it is only because of probably lobbying by our organizations and stuff saying, SSA, you've got to change this. We were bleeding representatives. No newbies could even start because they, you have to go like 2 years before you get your first fee, in theory, oftentimes. I mean, I've been in it so long, I have a pipeline that's robust and, everything's fine for me. But, we need good representatives. I'm not going to be here forever. I need good, ethical people following up. Solo practitioners, preferably, because I love them. But if they're not able to sustain doing this, it's already discounted at a $9,200 cap. If they can't sustain doing it, and they couldn't at 6,000, and we were bleeding good representatives, all you were left is like the factory outlet types. And then people like me who have been here long enough where it's not going to matter. If you knock the contingent, the way a contingent fee arrangement is meant for everyone's safety, everyone to be able to get an attorney, you to have an attorney and not have to pay $50,000 if you don't have that 25% contingent fee. Let's say you decided not to have done that 25% contingent fee. You said, I want to do fee petition. Okay. Because I don't think he's going to need that much work. You could have done that if he would do it too. So that would have to be agreed upon. Then he would submit his hours, and let's say he only did 10 hours at $300 an hour. And they would certainly assume he did 10 hours, on initial, I believe. I mean, interview alone, drafting up, maybe he had some internal meetings with his people like we do, or whatever. I don't know. Maybe not. Maybe it was 5 hours, 6 hours. But let's say it was 10 hours, $3,000. If he only charges $300 an hour as an attorney, because now you're looking at an attorney rate. And I'm telling you, most attorneys don't charge only $300 in this day and age for attorney work. Law schools just won't let you afford to do that, Let's say, and that was only if he did 10 hours. Let's say he did work. Let's say it went on. Let's say he filed when you wanted him to. You lost it initial because you were a little trigger happy with the filing. Didn't use a good strategy. And now you're going to an ALJ hearing and it's 2 years later and he's got to prepare for hearing. And now you're at 40 hours. What is 40 hours at 300? You wanted that fee petition. Remember, you didn't want the contingent. You didn't want that insurance that keeps it clipped, but, makes the 25%, but capped at 9,200. So there's not even really a minimum. It could still be zero, but capped at 9,200. Let's just do that math. If it was 40 hours times 300, 12, would you prefer that? You see what I'm saying? And I'm just curious. It's fine. Do you actually know? And I know this is a natural way you're thinking, so I'm not knocking you, but I'm just drilling home all the counterpoints. And I did this recently with somebody on paper, and it made me do a video on it, which you could take a listen to if you want, about all the reasons why not, why I think, and it's pretty much what I'm saying here. But, and it's recent, it's like in the last month. I gave a on paper, it was a message back to the person saying, I don't think you should because this, that, and that. And her point was well taken. She felt exactly like you did. Exactly. And I explained all the reasons why I didn't think it would be right, because you asked for this, you promised, and now you're trying to say, I want to break my promise because I don't think he really earned that much. But that's the whole point of a contingent. It's kind of like a flat fee in a way, although it's not a flat fee, right? Because they have the percentage. It's not merely contingent, it's also a percentage. But anyway, Inferno says, been in SSDI since 2005. All right, we're at the 2 hour and 20 minute mark, guys, just saying. So we'll probably try to get to the end of these questions. If you have questions, pop them in now, because I'm not gonna hold on. Been in SSDI since 2005 and 100% total and permanent from VA. All right, that was with regard to, oh, you're doing that international thing, right? So good for you. So you have SSD and you have 100% total. So you're one of my finer living friends. I'm happy for you. Very glad for my veterans that get some, if they're disabled, have the P&T, because you can live a much better life financially. It's a lot more. Thank goodness for VA. Inferno is age 50. Oh, so you did an age change. That's in your favor, very much so. On CDR, they have to take consideration your new higher age. Gina, is it Gina or Gina? You got the 3 N's though. I remember that from last week. I think it was last week, right? Good to see you, Gina. If I've already filled out an RFC with incomplete, vague info, as you described in other videos, will the ALJ be less likely to take me seriously if I fill out another one? You know what? You don't need to fill one out for the ALJ. I wouldn't, because I take that back. I'm not sure. I was going to say no, because you can testify to it all. If anything's changed, so I don't know what your vague and incompletes are. You could do it if you do it well. You know what I mean? Because written statements are things that can be used to impeach what you testify to. But if your testimony is going to be consistent with your second one, then it's fine. It's just that you got to make sure you're able to testify to what you put in your function report consistently. So if you can do that, and that's not something that's impossible, of course, you just have to, when you're studying for your hearing, review what you said in your function report. If something's changed, you're going to want to be honest at the ALJ hearing about what's changed. It could be that something got better, or it could be that something got worse. You still kind of have to be honest about even the things that get better, of course. You could do it. And the only reason I retracted a little bit about saying don't do it was because of what I just mentioned. But by doing it, your function report from before is probably a long time ago. And you could submit a new one and say, that one is a long time ago, and I realize now I really didn't answer thoroughly. I didn't really understand, and I was in a lot of pain, and maybe keep out the part about being in a lot of pain. But I understand now that, I should have been more clear and then explain. So I'm resubmitting this now with a better understanding, so that, if this helps understand my limitations better. And then, of course, you want to use that and be knowledgeable, and don't forget what you said, so that if you're at hearing and something has changed, you can explain, well, yeah, Judge, in August, I submitted a updated function report because I realized I just I didn't even think the other one through, and I just was really not answering things very well, and not accurately, because I was just making presumptions, Judge, of what I could do. And I later on, took it to heart and really kind of timed myself on things, see how long I could do things. The dogs are very annoying. They're saying, you've been in there over 2 hours. Come out and feed us. Yeah, I would, if you're going to do it, you can explain to him at hearing too. I submitted another function report, Judge, because I realized that I had kind of made presumptions about my abilities in the first one. And then I learned that wasn't really what I should be doing. And I wanted to make sure I had accurate information to you, which I can also discuss here with you today as well. You could do that. It's fine, says, I did not think about that. Thank you. Yeah, I know. And you know what? And that's no bad on you at all. It's normal. You probably are. So again, I don't know what the back benefits are. If your back benefits are $200 and he's getting $500, I don't think that's being overpaid, even for the mere conversation he had with you. And the filing, of course. I mean, that and filing certainly should be probably at least $1,500. But if you're paying him $9,200 and you're like, I feel like you didn't earn it, that's probably true. But he's not getting paid on the hours he put in because you didn't want him to. You wanted it to be on this contingent fee. He's got this safety net of sorts that can still fail him. And you have a definite safety net that you will always be able to have paid and secure an attorney. You didn't have to come up with the $9,200 as a retainer either. And that's part of the purpose as well. Virginia Gomez says, thank you so much. Keep up with your super kind help to us. May God bless you and your family. I would like God to bless me and my family too. Thank you. Yes, yes, yes. Gina says, also, if my lawyer isn't advising me on how to answer accurately and with enough detail, should I ask another lawyer or watch more videos like yours? Also, why wouldn't they explain? All right, I can't speak for your lawyer. Everyone's got different practices. If you were listening to what I spoke to about It's Fine up above, kind of discusses my take on what is an appropriate attorney involvement in their own client's case. But I'm not trying to backstab other lawyers here. I would like to see them step up a little more, but we've got the world we have. When you say ask another lawyer, I don't know that another lawyer is going to advise you. And we don't even do consultations for people with attorneys because that would be a conflict. What if, that attorney knows their case best and I can't presume to know it better than him or her. So that's one of our rules with our prepaid consultations. I only do it for people who don't have a lawyer. I don't know. So I don't think that you're going to get a lawyer to do that. I could be wrong. And if you're saying I would dump my lawyer to get another lawyer, you're going to really want to make sure you can get that other lawyer first. Because number one, your first lawyer is going to have a right to, this is in videos about when you dump your lawyer. There's a whole, look under appointed representatives. There is a playlist called that, and it describes for you the pros and cons of getting rid of your current representative, how it can cost you, how it can prevent you, won't necessarily, but can prevent you from getting another attorney to jump on board. And this would be particularly so for people who have more hurdles in their cases than other people. And I don't know your case, so I can't say whether you do or not, but it's something to think about. Take a look, see. That's under attorney, I think it's appointed representative. It's one of the playlists. There's a lot of playlists. I got to clean them up. I just don't have time. They were from when we first started, so they're a little bit of a mess. All right, next. We're almost down to the crunch, right, guys? Oh, it's fine, says the insurance analogy helped me feel better. Oh, God, I'm so glad. I got to use it more often. I use analogies so much, and so many people don't get them. Not in this arena, but, and the insurance one is good, but I use it in others because I'm involved in a few different areas, outside of my Social Security disability practice. And I will use analogies. It's fine. And some people will say, I can't believe you're comparing this group to that group. I'm like, you don't know what an analogy is. It's about the relationship. It's not about the two objects. It's about the relationship in between. This is to this as this is to this. These two things are not the same. And some people don't get it because you get it clearly because getting the insurance analogy. Anyway, all right. Thank you. It's fine. I appreciate that you took it in the vein in which it was intended, which is just to help you understand. And it's truly my beliefs on it. And I know I have a vested interest in fees being paid. So with that disclosure in mind, of course. Is that Mage 885? Okay. Alleging without. Okay. Can the SSA deny your claim if you refuse to have surgery? I don't know that the refusal to have surgery would be the strong basis of the denial. It's just one piece of the puzzle of whether or not you're actually impaired enough to not work full-time at all jobs in the economy. Can it be a crumb of consideration? Yes. If you don't, it can signal that you don't feel significant enough symptoms from your impairment to bother or go through the inconvenience and the pain and the risk of surgery. On the other hand, it is known that surgery comes with risks. Now there is, and I was just talking to someone about this, and I do have a video on it. They did put out a narrative, the SSA. I think it was an SSA thing. I don't think it was a court thing. About it's considered being non-compliant, potentially non-compliant with medical advice. Now, options for surgeries are not necessarily we're advising you to have the surgery. So you could kind of make that argument. It's just your options. You could take this risk or not take this risk, But I do always suggest, because, you do see rhetoric sometimes in denials that say, only had conservative treatment and didn't feel the need. It's a little obnoxious. Didn't feel the need for the recommended surgery, suggesting that the pain just wasn't as bad as they're alleging now. So I think you can help thwart that optic if someone's going to have that optic, and I don't know that they would. I think some adjudicators would be like, oh, heck no, I wouldn't have spinal surgery either. You know what I mean? So it depends on the subjective nature. We're all human, and you don't know who you're going to get, like a box of chocolates, right? So I suggest if you've been recommended surgery, the doctor is supposed to discuss with you the risks and all that to surgery. And there can be the general statement of that you want to put, you want to make sure it's clear. And you could do this in a portal message to the doctor so it's in the medical file or some other way. Because he might just say, refuse surgery in the medical. Sometimes the medical records just say it like that. And it's very unhelpful. And I resent it. They didn't just refuse it. They had reasons and they don't put it in there. But then a adjudicator or judge, usually a judge, can hang on and say, this did conservative therapies and just, didn't feel the need for surgery, refused it when it was offered, as if it's some like easy gift to accept. You could make clear, so it's in the record, like such as in a portal message to the doctor or somehow getting it in the record. Doctor, thank you for going over with me the surgery possibilities for my condition. I really appreciated you sharing the severe or serious risks involved, both in terms of the propensity for it to not always do what we intended to do and maybe not better after the surgery, as well as the risk of the surgery itself, both the fact that it can be fatal or the fact that it can cause other impairments, as well as the risk of blow. So you're making it clear on the record that you were discussed the risks and they are too much for you. And it's even stronger if the doctor did say, these come with general risks, but a lot of people opt for the surgery anyway. But let's say he then says to you, now with your high blood pressure, you're at a higher risk of stroke than most, and we can put you on blood thinners, whatever the limit. That would be added to your defense too. And then you also explain to me that given my comorbidities, you don't even have to go into the detail of what they are. Given my comorbidities, I am at a heightened risk beyond just the standard surgery risks. Now you've set yourself up differently, slightly, than the standard surgical population when there's no comorbidities. I would do that just to thwart if you're going to have a judge who is going to want to use that as one of the crumbs of denial to deny you. I mean, if a judge is going to deny you, he's going to deny you with or without, but that would thwart him using that as a basis successfully, potentially. You follow? And not all are going to use it against you, by the way. Many will be like, of course they don't have to do surgery. And the SSA says no one, first of all, they never make you do surgery and your case never truly hinges on it. But it's like I say, every little crumb the crumbs to build your case also includes keeping away the things that detract from your case, potentially detract. I'm very anal here. I know guys, you hear me threading a fine needle on both sides and I'm always trying to, but that's my nature. So if you can prevent something from detracting from your case while you're also building all this great stuff, like he's a surgical candidate, he's got, compressed disc that should use a decompression, you have all that stuff. Why not also, if you can, plug the holes of things that could leak out those crumbs? or otherwise diminish the case. So you're building it on this side and something else is pulling it down. If you can minimize that, it's for a stronger case. It's for a case that gets you closer to 100% win, which is impossible, then further from 100% win. So you can maybe be one of those people in the percentage that win those cases instead of the one that got the denial and has to refile or can't refile and has to file to the appeals council or something. So that's my anal nature. Gina says, I'm confused about how I can determine that the medical evidence I am turning in is enough, especially for diagnoses you can't. I add closer to my hearing, which will be very new with little substantiation. Well, if it's diagnosed, it's substantiated. I'm confused about how I can determine that the medical evidence. Well, you're never going to know until you have the judge's decision. I mean, you hand in everything that exists. So are you thinking of like, well, I did go to the, but I'm tired of collecting the medical evidence that I just went to, so I'm not going to. Don't do that. Everything you have should go in. In fact, legally, technically, if you have it, it has to go in, or else you're violating your rule. I see what I think you're saying. If I just got diagnosed with something a week ago and I haven't even had treatment for it, is it going to help? Well, it's not. I mean, it is, but it's not going to be big, obviously, because you were saying you were disabled long before then, and you obviously have much bigger things. But put it all in there. All in. It's fine, says. I'm not mad or anything. Just a little disappointed in the lack of communication, as you said, was important. And you know what? Those guys tick me off. It's fine. It's like they give a bad name. And they did, this is outside of SSD world. This was back when I used to do the state work. And honestly, it was horrible. It really was. I don't know how my friends that are still lawyers doing it. I don't know how they do it, because I know they're not like in love with it. Yeah. And those lawyers make the rest of us look really bad. So I apologize. I don't get offended when we're called snakes, because I think it's true. There's just those of us that aren't. So anyway, isn't that terrible of me to say? Sorry to all my colleagues. If you're the good ones, you know who I'm not talking about. All right. And you will have grace. Thank you. I'm glad you're not mad. RD says, why does this process take forever? I guess because we're all human, and you didn't, or some of us didn't get all the medical evidence we could get before we filed. So it takes that, and we're still treating, and it takes that. And then, it is a high bar to prove you can't do all 12,000 jobs in the economy. So most people will fail at that because they have to get the evidence, and they don't realize it. Most people concentrate on their bodies and what prevents them from the job they just had. I see it 90, maybe 100% of the time. And I'm like, okay, so we prove that you can't do the job you just had. All right. There's 11,999 other jobs. We got work to do. So that's why, other people. And then, of course, don't get me wrong, you've got the people that have to process it when it comes in. And when we had and maybe still have a system that's not running on all cylinders yet, but obviously running a little bit better than it was, 6 months ago. It's slow on the human side. Then you got people going on vacation. So then their caseload sits for 2 weeks while they're away on vacation. You got the medical expert at the, SSA that's on vacation, and he's the one that's going to be making your RFC. That's another delay. You got your doctor's offices who don't respond to the request for records in a timely fashion. That's a mistake. There's big news in the SSD circle, though. Very big. All like in this week, last week, and last month, of the technology that this current SSA is facilitating. It existed, but it wasn't being used as full force as it should be. So you get with, when any SSD claimant or SSI claimant has a claim, they submitted an 827 authorization. It's great because now the SSA can go order your records. And one of the ways it can now order them is through the technology. It's called like Mega Hit, or I call it HITMER when I see it in the evidence file, because it says HITMER. And I forget what it stands for. But I think their description of it is Mega Hit. That's what it's been called forever, but they have just expanded it. They want to be able to get your records super fast for you, instead of, sending a letter to the doctor's office, and then the doctor's secretary has to open the mail. And then she says, well, the person that copies medical records doesn't come in until the fourth Friday of the month. All these like manual reliances. And then of course the paper got lost. And so when the person came in on that Friday, they didn't see it. So, he'll be in a month though. And believe me, this is how things went. So it's trying to be all automated. So the official record set, which is not the same as your portal record set, can be gotten by the SSA literally in seconds. And what's good about it is I'll see a case that's on initial, and, with things still being slow, they might order them from your network with a HITMER. And then let's say you took a little bit of time to get your function report. They'll do another order they'll HITMR it again to see what came in the last 2 months while you were doing your function report and your work history report. And maybe you had a new doctor that hadn't yet examined you, but you said, but I'm going for an MRI. So you want them to wait, to get the MRI. So they can be ordering these records. They can be doing things and getting updated records much faster. And they're really talking about how more on steroids that process is becoming, because this administration is now really, it's so honed in on things have to move faster for all these people. The people that have the evidence from their doctors, and that's a whole nother thing, guys, about getting doctors and the medical profession itself to do a far better job recording. I'm going to give them a D. Yep. Okay. So shoot me. I'm giving them a D. There are exceptions. I'm talking about the industry as a whole. The portals are great. The cut and paste of what you were 3 years ago into today's visit is not great. I almost think they should make that an actual ethical violation that a medical provider can be reprimanded for or censured or sanctioned. Perhaps it should be a civil rights violation. I don't know. We have civil rights violations with HIPAA. So why isn't that one of them? That's sloppy record keeping where you look as healthy as you did 3 years ago and you're, sitting in a wheelchair. It makes no sense. How dare they cut and paste? How dare they cut and paste? Just saying. Okay. You asked the question. Sorry, RD. Mark A says, hello, I've been on SSDI since 2020 with a 5 to 7 year CDR. I just moved overseas to lower expenses. I understand. I'm 63 now. Will they mail me forms overseas or email me online? Make sure you change, giving them all your contact information of where you are. You change your address online. Good. Yeah, they will contact you in that way. It might be 2020. It might be you don't even get a CDR. You were 63, 5 years old. You were 58 at the time. You're already in that higher bracket, but they put you at 5 to 7, which means medical improvement not expected. I wouldn't be surprised if they just do a quickie overlook. You might be unaware of it altogether. They might not do it at all, or at worst do a short form, but do your job of following up with medical providers over there. I would say make a habit of every 6 months getting your records of your appointments, not just that you had them, but what the substance was. Whatever your impairment is that disables you, I'm assuming there's maybe more than one and you have more than one specialist, it's insurance. Yes, you might not need it and get a CDR and you went into the trouble of getting this is reminds me of what It's Fine and I were just discussing. Getting it doesn't mean you might not get a CDR and you might say, wow, I want all that energy back that I went and got those records because I didn't get the CDR now. Well, it was insurance in case you did have the CDR, but blessedly you did not get the CDR. So that's just something I would do, being very cautionary because the costs of losing are so high. So a little bit of effort, I don't think you're going to have a problem at all, Mark. I just, why not? If there's a 3% chance of having a problem, why don't we reduce that to 1%? I'm a math girl. All right. Oops. Where am I at? Gina with the 3 A's says it's pronounced Gina. So it is Gina, like a G. You probably spell it Gina in real life, right? And then probably that name was taken for YouTube. So you had to go with Gina, which is very cool, by the way. It's memorable. Gina's talking about her prior function report. She says, by incomplete vague, I meant things like not adding details about, yes, I can do this, but I have to limit my time. Oh, and I can only do it lying down, etc. Okay, getting more granular about it. Okay, so you're thinking the vagueness actually made you seem more fit than you were because you could do it. Yeah, maybe you should go do another one, Gina. Might not be a bad idea. Take your time with it and then submit it. I forget if you said you do have an attorney. I mean, I suppose you should talk to him about it. If you were a pro se, I'd be like, yeah, I would probably do it because you didn't realize. And that's an easy one to explain. I thought they were saying, can you just do it? Yeah, I get it done. It takes me 3 times as long. I do it over 3 days. I have to have breaks in between. Whatever it is, I don't do it as well. I don't clean my toilet as often. I only do it like once a month when I should be doing it every week, because I don't have that energy to do all those things every week. So I have to space them out, whatever the case is. But I get what you're saying, Gina. Yeah. Gina, you are so welcome. She says, thank you for all your answers. I appreciate the time and effort you put into helping us. It is, it's my privilege and pleasure, Gina. Alleging says, I recently had a failed surgery on my cervical spine, and now they want to do a laminectomy on my lumbar 5S1, but I don't really want to jump into it. I think you have another great defense if you want to add it to your crumb of defenses besides the generics that we were talking about before. Surgery has already failed you. So maybe your body is not the one that heals as well from surgery. Maybe you have scar tissue forming that some people get after these surgeries that causes them a problem. Make that clear. Just say, and even say, doctor, we discussed how my body did not well handle the first surgery and it was a failure. And if you can find any research that suggests that a person who has a failed surgery, and that's a body thing, right? We're all different, has even a bigger chance of a failed surgery on a different similar surgery of the same structure, which is the spine. I wonder if that exists. And if it is, then you could do a message saying, because I would imagine it's true. I just don't have any research to support that. You could say, we discussed that my body failed the surgery the first time. And apparently, as I know now, even if he didn't say it, you don't have to say he said it, but you could say, as I know now, the chances of a similar, a surgery on the same general kind of body part has a similar chance of failure. It doesn't seem worth the risk. And I really, and then you could close it off. So this is kind of like, I really appreciate you getting into all this with me, but we could, let's talk about more therapies and solutions without the surgery for now. We'll look at it again later, given the risks, something like that, because that is scary. And you've already had one. To me, that is you personally know that your body personally has failed already. And I'm not putting down your body, but you know what I mean? You have personal experience. You're not going off of the anecdotal or the general stats on the general population. Yours already failed. I don't think any judge is going to question that. That would be insanity, in my opinion. Gina says, little substantiation. That meant not much treatment, not much of a paper trail, not many doctor's notes. If I'm diagnosed a week before a hearing, the diagnosis is valid, but with very little. Yeah. I still think you still want to get it in. I wouldn't stop. Why would you? I wouldn't stop. It shows that you're going to have things going forward too. He's got that to see, things are still things are in your body. I would put him in. Gina says, I know, honestly, my throat is getting really sore. We're pushing on 3 hours. This is our longest probably. I'll likely have to ask next time as you've been on so long, but if I have almost 20 official diagnoses, but some are mild, moderate, will the totality of all those limitations possibly meet a listing? It would be equaling a listing, not meeting a listing. It's potential, but most people don't win on a listing. Usually that would happen. You can, but I honestly think most people it's on an RFC, but they will all contribute to that too. Definitely. And the mild to moderate ones are, as long as they're severe, and I know you're using it in a different context of what they say severe and non-severe is in the context of step 2. So I don't want to confuse you with that. It's different than the other things about mild, moderate in terms of tasks and capacities on the RFC. All right, Kitty is our last one, except maybe Gina right after. No more questions. Kitty says, I'm about to take out a personal loan to replace my roof. This will put me over the asset limit. Put me over the asset limit for several weeks during construction. No, I wouldn't put it in someone else's account, Kitty, because then you're overtly trying to fool the SSD. Can you pay it into escrow? And I haven't done the research on this. I'm just wondering if that could be a solution. Escrow means it's out of your hands and the escrow agent controls it in trust to pay to the construction person. I should have been drinking this all along. And document it well. The receipt of income will not be a resource unless it hangs over to the next month, right? If you put it immediately into escrow or you prepay, and I know nobody wants to prepay a contractor. I've made mistakes where I paid them too much and then they've walked on me 2 out of 3 times. I'm in the middle of working with Fourth, which I think will be fine because it was a personal referral from a close friend. But I wouldn't do it on the fly, slipping it into someone else's account. I would. What about this? Can you pay with a credit card? You never see the cash, and it is always clearly a loan. Even if you get the personal loan to then pay off the credit card, maybe that would be better. Loaned money is not income because it's borrowed, but if it stays in your account into the next month, it is a resource, is my understanding. And that is your concern, that you're on SSI, right? So Kitty, if you're on SSD, this doesn't matter and it's not a problem. You could do whatever you want. We're only talking if it's SSI. So confirm that, all right? If it's SSD, you can do whatever you want. Okay, Gina, I'm just gonna hit you up. To answer yes, I think the way I filled it out before made me seem more fit because I didn't add the T. Yeah, I think it's important because those ways we word it are used in ALJ denials. And then when we're saying it the correct way on the stand, they're like, that wasn't consistent with what you said before. But now you're actually correcting it in advance and saying, this needs more clarification because I didn't realize I should be, I didn't realize it would be more illustrating the realities, however you're going to say it, you know, like I could do it, but like this, you know. Yeah, Gina, equal a listing rather than me. But like you said, no more for now. Thank you so much. You bet. Guys, it's been great. It's been long. I love my Wednesdays. Can you tell? All right. And everybody, thank you so much for your kind words. Do feel free to subscribe if you haven't, and definitely like and share. The replay of this, sans all the gaps in time where I was reading and whatnot, will be removed. And if the software isn't too slow, it will be up tomorrow morning, tomorrow noon. Anyway, all right. Thanks, guys. I appreciate it. And Kitty, you're welcome. Thank you so much. She says, I am SSDI. Oh my gosh, thank God I mentioned that. Because when I first read it, I'm like, oh, she must be SSI. And at the end, I'm like, what if she's not? I didn't want to put it somewhere else either because that's a huge risk. I didn't know about the month due rule. Yeah, but that doesn't apply to you with SSDI. It's SSI because that's welfare. If you have money, you don't need to take it from the taxpayer. You are not taking money from the taxpayers. You are collecting on the insurance that you bought and paid for all those years of work. Yeah, you know, and taking out a loan shouldn't show up on a W-2 with wages or anything like that either. Just always keep your documentation just in case, but I don't think it will. All right. Oh, I'm so glad you said that. All right. Have a great one. I'll talk to you. Remember, next Wednesday, 1 o'clock p.m., 12 o'clock noon every day for a pre-recorded video that come out daily. Sometimes they came out the night before. It depends. If I need to sneak it in there, I'll bump other ones further. And that's how it gets a little cattywampus sometimes. But anyway, so good to see you guys. Have a great rest of your week. I am leaving for Jersey on Friday. Very excited. I am working, but I'm also going to be near the shore. So I'm going to get a little of that fun time. And I'm going to use that metal detector if my friend is watching, which I don't think he is. I really appreciate that birthday present. So that shouldn't have done it, but I appreciate it. You're welcome. Desi S., you're welcome. I know we didn't talk, but I guess you're listening in, so that's good. KR says ex-hubby spouse benefits. KR, we're out of here, but will it be less if I'm under FRA? Yeah, for sure. If you can wait till you're FRA, then you get 100. You get the maximum amount of spousal you can get. If you take it before FRA, you're getting that discount because you're taking extra months of benefits that are early before your retirement age. Okay. Thanks, KR. I will have a good time, and you have a good time too. Whatever you do, everyone stay safe, and thank you so much. And God bless. Bye-bye, guys.